So I'm going to call Panel A meeting to order and ask for roll to be given. So Dr. Diaz is here, Dr. Simonson is here, Barbara Yaroslavsky is here, Dr. Bishop is here, Mr. Serrano-Sul is here, so we're all present and accounted for. And I'm going to turn now the meeting over to our judge. Thank you.
Good morning, everyone. I'm Mary Margaret Anderson. I'm an administrative law judge with the Office of Administrative Hearing, and I have the pleasure and honor of assisting the panel today with these three cases for oral argument. So we'll start with the matter of Andreas George Alice. Would counsel and Mr. Alice please approach? Okay, while they get settled, just go over what the general protocols will be for all three matters that are on the calendar this morning. The respondent licensee will have 15 minutes of argument, the Deputy Attorney General 15 minutes, the respondent licensee again 5 minutes, and the Deputy Attorney General 5 minutes. The panel may ask questions, but no new evidence will be presented or heard or considered today in these proceedings. So I will call the case. I see counsel and respondent are present. Calling the case today before the Medical Board of California in the matter of the statement of issues against Andreas George Alice, that's AHLAS. The case number is 20-2012-221204. The OEH number is 2012-040-368. And today's date is January 30, 2013. It's a little after 8:30 in the morning. We're at the meeting at the Embassy Suites Hotel in Burlingame, and all notices have been given as provided by law. So I'll ask first for appearance of counsel, beginning with the Attorney General's office.
Good morning, Deputy Attorney General Emily Brinkman on behalf of the board.
Good morning, Paul Chan on behalf of the respondent applicant Andreas Alice.
Good morning, Mr. Chan. Are you ready to begin?
I am. Good morning, everyone and the member of the board. I reviewed the complainant's written argument after the non-adoption, and I'm hoping that each member of the board had a chance to review the arguments I submitted on behalf of the respondent, Andreas Alice. The issue in this case is that the matter went to hearing, and the proposed decision was not adopted by the board. And I believe that the board wanted the argument to focus on the argument of whether or not the proposed order is sufficient to protect the public. In reviewing the complainant's, meaning the board's own argument, I guess the recommendation is that the proposed order of a public reprimand does indeed is sufficient to protect the public, and that the decision itself should be adopted. Obviously, my client is the desire to begin his career as a doctor in the state of California, and he would hope that the medical board would adopt the decision. I don't know how much argument, or does the board have any questions directed for Mr. Alice, given that the issue seems to be, maybe I'm reading it wrong, but it seems to be a non-issue since the board's decision is that the proposed order should be adopted. With that said, I don't want to take a whole lot of time. I'd rather leave it to just questions, each member to the board, if there are any.
Do any of the board members have questions for Mr. Chan? Okay. I don't hear any, Mr. Chan. Right.
Well, in that case, I'll reserve any additional statements for my time for the closing statements.
Okay. We'll try to accommodate that.
Great, thank you.
Thank you. Ms. Brinkman?
The board's main question in the notice of argument is the public protected with the public letter of reprimand? And I just point out that Judge Crowell at the hearing and in the proposed decision had an opportunity to observe the witness, the applicant, to talk to his witness over the phone and hear or read letters in his support. So she had an opportunity to look at the character of Dr. Arliss. And the board can rely and provide great weight to Judge Crowell's holding or findings on character. I think the board's initial concern with the denial was perhaps this applicant was trying to commit a fraud on the board. But then after the hearing and listening to the evidence presented by the applicant, it was clear that this was really just a dumb mistake. It was not done maliciously or with an intent to commit a fraud on the board. And so that was the evidence that appears that through the record has come out. So I think the letter of public reprimand does in fact protect the public. It will be on the website. It will be in his for 3 years. So future employers will be able to access this information as well as any prospective patients. So this information is out there, and I think that is sufficient for public protection.
Thank you, Ms. Brinkman. Mr. Chan?
Yes. Yeah. In closing, I just want to stress that my client truly regrets the mistake and caused what it caused as far as this whole process. And we truly appreciate this opportunity to be heard, to be presented, and hopes that the board will adopt a decision and realize that the public reprimand is sufficient discipline and protection for the public. And my client would like nothing more than to commence his career as a medical doctor in the state of California. Thank you very much.
Thank you. Do any members of the panel have any questions?
The letter of reprimand stays on the website. How long?
Well, the regulations say that the public letter of reprimand is good for 3 years. It's really unclear from the regulations that how long it stays on the website. Someone with the board enforcement might have a better understanding of how long that stays, whether it's beyond the 3 years.
I can provide some clarification. Under the code, it actually states that a public letter of reprimand shall be purged after 3 years of issuance. It's always been my understanding that there's actually a process that the individual will have to go through to have the letter of reprimand removed after the period of 3 years has passed.
If we need further clarification, I think Mr. Hepler has the code in front of him. Mr. Hepler, did you have any clarification further?
Okay, so since we're on the record, so you need to identify yourself, Mr. Hepler, for the court reporter, please.
Kurt Hepler, Staff Counsel, Medical Board of California, on the narrow issue of a public reprimand issued under Section 2221.05 of the Business Reference Code. There is a little bit of discrepancy. A public letter of reprimand issued concurrently with physicians and certain certificates.
Okay, Mr. Hepler, I'm sorry, you have to slow down for the reporter. Yeah, sitting down will help you slow down, I think. Okay,
Let me try this again.
thank you.
Good morning, members. Pursuant to Section 2221 a letter of reprimand issued concurrently with the certificate of medical license shall be purged from medical files within 3 years of the date of issuance. Obviously, if it's purged, then it can no longer be on the website.
Thank you. Okay, the protocols, I know we're just about done, but the protocols also provide that I'm to offer the respondent physician an opportunity to address the panel personally to tell the panel why he believes that the proposed penalty should, well, what he believes the proposed penalty should be. So that's absolutely up to you, Mr. Arliss.
I would like to take this opportunity to thank the members of the board for taking the time to hear my matter. I have learned a great lesson from this experience, and I fully intend to fulfill my duties as a physician in the state of California with the highest professionalism and ethics. With great sincerity and humility, I am requesting that this board adopts the proposed decision from the administrative law judge. Thank you.
Thank you very much, Mr. Ellis. Is there anything else for the record this morning in this matter? Hearing nothing, we're off the record in the Ellis matter. Thank you very much.
My name is Mary Margaret Anderson. I'm an administrative law judge assigned to assist the board this morning. We're at the Embassy Suites Hotel, which is the time and place set for hearing January 30th, 2013, 9:45 a.m. May I have the appearance of counsel beginning with the Attorney General's office?
I am Deputy Attorney General Esther Law.
Good morning. I'm Steve Zeigen, representing Dr. Bell, who's sitting next to me at council table.
Thank you. All right, so in accordance with the protocol for oral arguments, we'll proceed with 15 minutes each from each representative, and then each side will have 5 minutes for rebuttal. So, Mr. Zeigen, are you ready to proceed with your 15 minutes?
I am, Your Honor. I'm going to ask this panel to consider the following question, and that is, when is enough enough? Let's look at the impact Dr. Bell's actions during his residency have had on his career and what the evidence has demonstrated with respect to Dr. Bell's being able to practice safely and ethically. Because this board chose to outright deny his application for licensure, Dr. Bell first lost the opportunity to participate in an orthopedic trauma fellowship at UCSD. Because the board denied him the opportunity to withdraw his application at the time he applied, he's had to endure the cost of going to hearing, while at the same time having his application for licensure in the state of Texas expire while Texas was waiting for this board to reach a final resolution. Since 2011, Dr. Bell has clearly demonstrated he has no substance abuse problem and has such integrity that the director of the New Jersey Physician Assistance Program wrote directly to this board a letter of recommendation on his behalf suggesting he receive his California licensure. He was examined and treated by a California psychiatrist, Dr. Ganajian, who both wrote a letter to the board and testified at the hearing. There is no characterological flaw to Dr. Bell's practicing safely and ethically in California. Now, rather than be a participant to his own pity party, Dr. Bell, since November of 2011, has worked as an orthopedic surgeon at the Gallup Indian Medical Center in Gallup, New Mexico, where he has literally performed hundreds and hundreds of procedures, some of a very significant trauma nature, on Native Americans, helping them to again lead productive lives. Excuse me. The director of GIMC, Gallup Indian Medical Center, Dr. Catherine Hawthorne, who was also licensed in California, testified at the hearing. Her testimony was unequivocal in support of Dr. Bell, not only as a skilled surgeon, but as someone who has exhibited sound judgment, high ethical standards, and whose judgment she has never had to question. Now, I'm going to make a few references directly to the transcript so the panel can look at it if they so choose afterwards. At page 144 of the transcript, Dr. Hawthorne refers to Dr. Bell as one of her top producers. On that same page, she indicates he had performed over 208 operative procedures through August of 2012. That's in addition to 12,000 clinic visits, clinic appointments, which also included minor procedures. That, again, is at 144 of the transcript. 145 of the transcript, she describes Dr. Bell as meticulous, courteous, trying to educate. At 150 of the transcript, she said she has never questioned his integrity nor his medical or personal judgment. This is the evidence upon which Administrative Law Johnson found Dr. Bell's use of the pre-signed scripts of the residents in New Jersey to have been an aberration of behavior. Aberration means it's not likely to be repeated. This is the same conclusion reached by Dr. Ganagian. It is for this reason Judge Johnson rendered what I consider to be, panel members, the greatest amount of discipline which this case warrants, not the least, the greatest, which was the issuance of a license following the completion of an ethics course with a public reprimand attached to it. But I submit to you at this time, this notion of an ethics course is really a red herring, given everything Dr. Bell has done since 2011. But we're here today because the board non-adopted Judge Johnson's decision, presumably questioning the wisdom of the discipline imposed. And from our standpoint, I'm hoping the question of the discipline imposed is why even bother with the ethics course given the evidence that was introduced. Now we have Ms. Law, on behalf of the AG's office, representing the board, requesting 5 years probation because the judge mistakenly referred to Dr. Bell's conduct as occurring over the course of 1 rather than 2 years. Ladies and gentlemen of the panel, I submit it is time this board adhere to the proposition established in case law for more than 25 years that discipline is not designed to punish the license holder. It is designed to protect the public. It's also designed to, and I'm quoting from Ettinger now, protect the public from dishonest, immoral, disreputable, or incompetent practitioners. Therefore, there are 2 elements to this notion of public protection, neither of which I submit are applicable to Dr. Bell. First, based on everything we know about Dr. Bell's ability as a surgeon through the testimony of Dr. Hawthorne and the character letters received from the staff members at GIMC, he is clearly not an incompetent practitioner. Next, is he, because he used those scripts, as we sit before you now, dishonest, immoral, disreputable? Is he a dishonest, immoral, disreputable practitioner to the point where the public needs protecting? Given what's transpired in the last 2 years, the answer to that's a resounding no. First of all, his New Jersey license was unencumbered after investigation by the New Jersey authorities, after his participation in the New Jersey PAP, Physician Assistant Program, after his examination by a New Jersey psychiatrist, Dr. Gray. He even received letters from the director of New Jersey's PAP, Dr. Baxter, supporting his application for licensure in California. Next, Dr. Ganagian, who I referred to earlier, testified to the same conclusion after he was sought out by Dr. Bell on Dr. Bell's own volition. We know from his conduct at GIMC he is skillful, trusted, reliable, honest, caring, devoid of any semblance of a characterological flaw from which the public needs protecting. In fact, the contrary is true. Allowing him to practice based upon his record protects the public, is beneficial to the public. In her papers, Ms. Law insists, as she did at trial, the period of rehabilitation has not been long enough. I'm going to read briefly page 172 of the hearing transcript, the statement that Ms. Law made. And I'm quoting now. It's lines 3 through 7. Proof of rehabilitation includes, at a minimum, a lengthy period of not only unblemished but exemplary conduct. And that has not been demonstrated because there's not been enough time that has passed, close quotes. How long do we push this process out, panel members? How long is enough? How long does Dr. Bell have to keep carrying the scarlet letter from that which occurred in 2011? He demonstrated at hearing that his time at GIMC is greater than any 2-day ethics course he could take, greater than any online ethics course for which he'd have to answer questions, which would be any kind of condition preceding to the issuance of a PLR. I submit to you, as I did at the hearing, rehabilitation is not simply a quantitative analysis. It is by nature, given the impact, the significant impact probation has on a practitioner's ability to practice, also a qualitative analysis. And in this latter regard, there can be no disagreement. Dr. Bell has shown his rehabilitation. Accordingly, panel, imposing any kind of discipline against Dr. Bell at this time, more than 2 years, given his conduct 2 years ago, given what we know about Dr. Bell's conduct in the past 2 years, and what he has done at GIMC, would constitute impermissible punishment. I ask you to give a reasonable interpretation of the meaning of rehabilitation and abide by the legal principles cited at page 5 of my written argument. Quote, "The law looks with favor upon rewarding with the opportunity to serve one who has achieved reformation and regeneration. Without question, this tenet applies to Dr. Bell. He is every bit remorseful today as he was 2 years ago. And everything he's done in the last 2 years has been evidence of that fact. And I ask the panel to act accordingly." Thank you.
Thank you very much, Mr. Zeiken. Ms. Law?
Good morning, honorable board members. I'd like to first briefly go over the factual background of the case because it bears directly on the issue of the amount of discipline that's appropriate here. Dr. Bell submitted an application for licensure 2 years ago on February 1st, 2011. And at that time, he was in his last year of a 5-year residency program in New Jersey. A week later, on February 7th, 2011, a criminal complaint was filed against Dr. Bell in New Brunswick, New Jersey, charging him with theft by deception. And the criminal complaint was based on allegations by a pharmacy that Dr. Bell had presented unauthorized prescriptions to obtain controlled substances for himself. Dr. Bell eventually pleaded guilty to a reduced charge of disorderly conduct in May of 2011. When Dr. Bell's residency program learned about his use of unauthorized prescriptions, he was placed under investigation and he was required to enroll in the PAP program of the Professional Assistance Program of New Jersey. And Dr. Bell enrolled in that program on February 10th, 2011, but he didn't complete the program. He only was in the program for 4 months because he moved to California in June of 2011. And it wasn't until 3 months after the criminal complaint had been filed against Dr. Bell, and after 3 months of his enrollment in the PAP program, that Dr. Bell finally disclosed to the board in an addendum to his California license application the facts of the criminal complaint, his enrollment in PAP, and his guilty plea. And all of these facts are undisputed. Moreover, at the hearing before the ALJ on August 24th, 2012, Dr. Bell not only admitted that he had used pre-signed unauthorized prescriptions belonging to other residents without their knowledge, but that he had done so regularly for the course of over 2 years. And this is a critical fact. It's not the 1-year time period that the ALJ mistakenly believed. Dr. Bell testified that he began using these unauthorized pre-signed scripts sometime towards the end of his 2nd year of residency or the beginning of his 3rd year of residency, and he continued using these unauthorized scripts until he finally got caught during his 5th year of residency. That's a period of approximately 2.5 years and even close to 3 years. He also revealed that he had used unauthorized scripts to obtain 4 different medications, Effexor, Wellbutrin, Ambien, and Provigil, and these last 2 are controlled substances. He also testified that he presented these unauthorized scripts for each of these drugs every 3 to 4 months. So that means he was presenting 12 to 16 unauthorized scripts per year for over 2 years. That is not an aberration. An aberration suggests a 1 or 2 time event. This is 12 to 16 separate presentations of scripts over the course each year for 2.5 years. Dr. Bell also testified that during the time he was presenting these unauthorized scripts, he knew that it was wrong and illegal. Yet, he continued this pattern of illegal and dishonest acts for 2.5 years. Now, the ALJ found that cause exists to deny Dr. Bell's application based on his criminal and dishonest acts. But rather than deny his application, the ALJ gave considerable weight to the evidence of rehabilitation submitted by Dr. Bell. But as I stated earlier, the ALJ's decision was incorrect in that she didn't properly weigh the relevant criteria in evaluating Dr. Bell's rehabilitation, because she was mistaken in believing that the conduct only occurred for less than a year. The Code of Regulations, Title 16, Section 1390, sets forth 5 criteria that should be considered when evaluating the rehabilitation of an applicant for licensure. And the ALJ did not properly consider 2 of these criteria. Criteria A is the nature and severity of the acts or crimes under consideration. And again, the ALJ mistakenly believed that Dr. Bell's unauthorized use of these pre-signed prescriptions occurred for less than a year, when in fact it was closer to 3 years. And the ALJ also did not consider another important criteria, and that's the time that had elapsed since the time of the commission of these acts. The ALJ's proposed decision makes no mention of this factor at all. So considering the nature and severity of Dr. Bell's dishonest acts, I submit that 1.5 years was not sufficient time to evaluate whether he had been fully rehabilitated. It should be pointed out that Dr. Bell's use of these unauthorized prescriptions was not something that he did years before he applied for licensure, but it was an ongoing pattern, and that he continued this act even after he filed his application for licensure. And Dr. Bell also did not promptly disclose the fact that he had been criminally charged and that he had been required to enroll in PAP, but waited 3 months to disclose these significant facts. Business and Professions Code 2221.05 provides that a public letter of reprimand may be issued to an applicant who has committed minor violations. And I submit that the repeated use of unauthorized prescriptions to fraudulently obtain medications for himself for a 2.5-year period cannot be considered a minor violation. As Mr. Zeigen stated, the board has a duty to protect the public from dishonest practitioners. And Dr. Bell has demonstrated that he was dishonest. He engaged in a pattern of criminal and dishonest acts for 2.5 years. And in light of his past conduct, there are legitimate concerns whether Dr. Bell can conduct his professional affairs with integrity and in an honest manner. Not enough time has passed to show that Dr. Bell is fully rehabilitated. And so, as I stated in my written argument, if a license is going to issue at all, an appropriate license would be a probationary license for 5 years. Thank you.
Thank you, Ms. Law. So over to you, Mr. Zeigen, for 5 minutes.
Thank you, Your Honor. Very briefly, I think it's important, number one, to consider the fact that what Dr. Bell ultimately pled to was a municipal ordinance, not even a penal statute. Municipal ordinance for disorderly conduct. Number two, he didn't complete the PAP because he came to California, and yet his 4 months at the New Jersey PAP program were such to warrant Dr. Baxter's writing a letter in support of Dr. Bell for California. Three, the reason he waited 3 months, very simply, and Ms. Law left a lot of stuff out of her presentation today, was that he was waiting for the review, the final review by the New Jersey Medical Board. He was also waiting for the plea, which happened in May, and as soon as that happened, all those things occurred, he notified the California Board. So it was actually exemplary conduct even then. Most significantly, he did not do any prescriptions after applying to the California Board. He applied to the California Board in February. This all came down at the end of January and February 2 of 2011. So that's absolutely wrong and contrary to the record. With regards to what is serious conduct, I ask you to look at Ms. Law's argument, page 3. She refers to the California Code of Regulations, section 1309, and the circumstances involved with rehabilitation. A, the nature and severity of the acts under consideration. They are serious, but there were also significant mitigating factors which were all adduced at the hearing with respect to, A, the fact he took these medications when he was in med school in Oklahoma. He had taken these medications by using the sign script of a resident with his knowledge before, and given the circumstances he found himself in with a demonic chief resident, unfortunately he made these poor decisions. But there were significant mitigating circumstances which denigrated the notion of the severity of his conduct, which obviously impressed Judge Johnson. C, the time that has elapsed since commission of the acts. I've already gone into that. It's significant not only in the amount of time, but in what Dr. Bell has done since that time. The extent to which applicant has complied with any terms of parole, etc. Obviously that wasn't applicable, but his voluntary immersion into programs to keep continuing this notion that he's clean by voluntarily submitting to testing, even though he had no issue of substance abuse, shows the nature of Dr. Bell's conduct. And then E, evidence, if any, of rehabilitation. I've already gone into that. The fact of the matter is, ladies and gentlemen, that Dr. Bell has shown a significant, worthy amount of rehabilitation. And what Ms. Law would do is continue to have this clock run regardless, and to continue to, and 5 years probation would allow this mark to stay against Dr. Bell for the next 5 years, requiring him to answer that question on all his subsequent applications, would preclude him from getting his certification in orthopedic surgery, and is just punishment. The AG's office has not addressed the notion that discipline is not punishment. And what we have shown in terms of the counterbalances is that anything greater than what Judge Johnson did would be punishment, and from our perspective, even what Judge Johnson did was punishment based upon what evidence we've shown with respect to Dr. Bell and his rehabilitation. Thank you.
Thank you, Mr. Zeigen. Ms. Law, do you have anything further?
Yes, thank you. I think Mr. Zeigen's attempt to minimize Dr. Bell's criminal conduct by stating that it was reduced to a municipal ordinance violation is disingenuous, because the underlying act was a criminal act. The fact that he was able to get it reduced to a municipal ordinance violation does not lessen the nature and severity of the underlying act. And the record shows that Dr. Bell did present false prescriptions after he applied for a license in California. He signed and submitted his application on February 1st, 2011. And if you look at the police report, which was Exhibit 4 to the complainant's exhibits, an incident occurred on February 3rd, 2011, 2 days after he submitted his application. And there are no mitigating circumstances for what Dr. Bell did. Self-prescribing controlled substances is inexcusable under any circumstances. And To the extent Dr. Bell says he was highly stressed, he was too busy, and those are not mitigating circumstances. And this is not an issue about punishment. The board should always be concerned about public safety whenever a physician or an applicant has demonstrated a pattern of dishonesty, and that is what Dr. Bell has demonstrated, a pattern of dishonesty for over 2.5 years.
Thank you. Do any of the board members have any questions for counsel? Okay, I want to thank counsel. Also, the rules for these proceedings state that the physician should be offered an opportunity to address the board directly. So, Dr. Bell, did you wish to address the board directly about your case?
Ladies and gentlemen of the Medical Board of California, I appreciate the opportunity to be here with you today, although I apologize for the circumstances which have brought us to this juncture. The goal of this statement today is to give you some personal insight into the past 5 years and to reassure you of the profound impact they have had on my life to this point. At the conclusion of these proceedings, you will be given the ability to decide my fate in obtaining a certificate to practice medicine in the state of California. I'm hopeful that after careful review of the materials that you will grant me that privilege. Make no mistake about my intention today. I'm not here to recant excuses, redirect blame, or make light of the situation before you. 4 years ago, I was in a very dark place in my life. While it's true what Mrs. Law said, there was a lot of stressors going on that are not uncommon to a resident. I had moved across the country, and most of these stressors were due to my career path, and I did come into contact with a chief resident that made my life and my job very miserable. And while that's no excuse for my actions, the verbal abuse did escalate to physical threats, and for the most part, my questioning for help was unanswered. And while this started out, the prescribing in an appropriate manner, it obviously evolved to something that was not appropriate. I came to work every day for 6 months in complete misery and fear, and it all seems very silly in retrospect, but it was so real for me at that point. And it doesn't really make better the decisions I made, but I can only say that under great personal duress, I made the ignorant and irresponsible decision to handle it the way that I did. And I'm not proud of this decision. I still wake up every morning praying that this whole ordeal was a very terrible, elaborate nightmare. And then I come to grips with the reality that I've created, knowing that I cannot change the past and I should not dwell on it. And therefore, I have striven daily for the last 2 years to prove to myself and to others that I'm not the person that I was back then. And I believe that I have demonstrated this reformation in my time at Gallup Indian Medical Center, where I've been working for the last 15 months. There I am lauded for my integrity, my competence, and my completeness, and for my caring of the patients. It took me a very long time to forgive myself and to move on with my life. But forgiving does not mean forgotten. And now I seek forgiveness from the Medical Board of California. I'm not a bad person, I'm not an unethical person, and I'm not a bad physician. And I think, in fact, most people would suggest just the contrary. Now I'm a well-trained, well-adapted physician who has developed more sophisticated coping mechanisms to deal with these life stressors. As you consider the possible outcomes of my request for licensure, I ask that you reflect on the things that I have endured over the last few years and take that into consideration. Regardless of the outcome in California, I still will be dealing with this from here on out on every application, every medical staff interview that I go into, and I know that that's not a bearing on your decision, but this is not the end for me, regardless of how it ends here. My wife is now 8 months pregnant with our first child, Madeline Lucille, and that is why she could not be here with me to support my endeavors today. We long for the chance to relocate to a place closer to our families, and we hope that you will allow us to act on that plan. I hope that you will see that everything I've done over the last 2 years has been towards this end, and I appreciate your time and consideration of this matter. Thank you.
Thank you very much. Is there anything else for the record this morning? Okay. Then that concludes this case, and we're off the record. We'd ask that the room be cleared so the board can deliberate. Thank you. Good morning again, everyone. We're on the record before the Medical Board of California in the matter of the accusation against Yuan Huang Lin, MD, and the case number is 10-2009-201310. The OAH number is 2011-120634. My name's Mary Margaret Anderson. I'm an administrative law judge assigned to assist the board this morning. Today's date is January 31, 2013. It's a little after 11 o'clock, and we're at the Embassy Suites Hotel, the time and place set for this oral argument proceeding. We have the appearances of counsel beginning with the Department of Justice.
Good morning, Your Honor, members of the panel. My name is Matt Davis. I'm a Deputy Attorney General, and I represent the complainant, Linda K. Whitney, in this matter.
Thank you.
Good morning, Your Honor. Good morning, members of the panel. My name is Matt Rippett. I represent Dr. Lin, who's seated here.
Thank you. So as I'm sure these experienced counsel know, the rules provide that each will have 15 minutes for an opening statement, beginning with respondent, and then each will have 5 minutes for rebuttal. So, is it Rifkin?
Thank you.
Riffin.
Thank you, members of the panel. I'm sure everybody has already read the briefing in the case. It is a relatively straightforward case, as I've discussed with the Attorney General. And today I want to cover, in summary, 3 things. The first is that when you look at the record that was adduced at the hearing, all the evidence that was presented, it's evident that what we have at its heart is not a lack of confidence, not incompetence or a lack of knowledge. It is a miscommunication. It is an inability or a disconnect in the context of an investigatory interview some 2 years after the fact in the midst of underlying civil litigation with a practitioner whose English skills are adequate and appropriate for what he does in the OR and in his practice, but in the context of quasi-legal proceedings are not entirely adequate and require more precision. So the nexus between what Dr. Lin is faulted for, that is answering effectively 3 questions incorrectly in the context of an investigatory interview, and incompetence or lack of knowledge is just absent. The second thing is that I want you to, in terms of looking at the record, and I know you all will look at the record very carefully and look at the arguments very carefully, is that there is a failure on the part of the complainant to prove. There's no convincing evidence, no clear and convincing evidence of incompetence or lack of knowledge on the part of Dr. Lin. In fact, to the contrary, there is unrebutted proof as to his competency, his character, and his reputation and skill within the community. And then the final thing that I would ask you to turn your attention to would be the best evidence of his competency, and that is twofold. One, it is the character witnesses that he presented at the hearing, and 2, it is his discussion, his somewhat detailed and elaborate discussion of each of the cases involved here. Let me turn to that part first. We all know, hopefully, that we have 2 patients at issue here, patient GR, patient LK. Patient GR and LK both expired following mitral valve repair surgery, which ultimately ended up being mitral valve replacement surgery in both instances. But both patients expired. And there were questions factually at the time of Dr. Lin's investigatory interview about what were the causes of the deaths and what sort of decisions and
thinking he had in the course of his care and treatment of these patients. Patient GR, one of the issues raised was venous drainage that Dr. Lin observed intraoperatively. With patient LK, there were two issues. One was the interaction of protamine with the patient during sort of immediate the end of the perioperative course, and what happened relative to ischemia in one of the patient's extremities. And let me just very quickly go through each of those in terms of what happened in the course of the investigatory interview. And I think it's important, and the record shows this, to understand that Dr. Lin, at the time of his interview, and his interview was in 2010, his care and treatment of these patients was in 2009 and 2008. So some time had passed between his care and treatment of patients and his interview. Beyond the passage of time, he also had litigation ongoing in both cases. At the time, when he testified to this at the hearing, he was receiving all sorts of different opinions and theories about what may or may not have been appropriate in terms of his care and treatment of these patients. Dr. Lin is a very conscientious individual. I know he wants to speak to you as soon as the attorneys are done with what they need to do. And I think you'll see how conscientious he is. So he took in all of the information that he was being deluged with. And at the end of the day, following a number of different questions, alternatively on the same topic by the investigators, including a consultant who, at least as far as the record reveals, did not have experience or knowledge in the field of cardiothoracic surgery. At the end of the day, Dr. Lin misspoke. And that is basically what we're left with here. At the time of the hearing, the proof was basically unrebutted that Dr. Lin understood that it was possible, at least with respect to patient GR, to diagnose pulmonary emboli preoperatively, but that he was musing about or speculating about whether microscopic emboli may have contributed to problems that he encountered during surgery. And if you look at the record, it's expressly there. He's basically asked to speculate. And I qualified that. I shouldn't. He is asked to speculate in hindsight as to what sort of contributing factors there might have been. Dr. Lin explained in his testimony with respect to patient GR that at the end of the day, he's really not terribly concerned intraoperatively with why his operative field is congested. And you all know this from having gone through the record, but basically he's looking at a valve. He's trying to repair the valve. If the field where he's doing his operation is congested, that is, has fluid or blood or any drainage in it, it's going to be difficult for him to see what he's doing. So is he concerned about what's causing that? Yes, in the back of his head he is, and he testified to that. But more important to him is what techniques and modalities do I need to apply to clear my field? What do I need to do to ensure that I can actually see what I'm doing? That's his preoccupation. In terms of the overall course of the patient, the demise of the patient and the like, none of this venous drainage is an issue for him. It's not a source of preoccupation for him for years and years until his interview. Then with respect to patient LK, on the two issues there, he's asked to speculate again. He's asked to speculate about protamine. As you know from the record, use heparin as an anticoagulant in the course of this surgery so that you don't run into issues with coagulation. And then once you've concluded that your repair is appropriate and complete, and the patient can be decannulated, that is taken off of the bypass system, then you apply protamine to reverse the anticoagulant effects of heparin. Dr. Lin had decided in the course of his surgery that the patient was stable enough, in collaboration with the other members of his surgical team, of course he is captain of the ship, decided the patient was stable enough to decannulate. And the patient was decannulated. Protamine was applied over a long period of time, about 20 minutes. The patient suddenly crashed. Now, as far as Dr. Lin's concerned, surgical techniques appropriate, his monitoring of the patient's appropriate, the use of medications, vasopressors and the like, all appropriate. So he's left with, why did this happen? Why did the patient expire? And again, he was asked at the time of the interview to speculate about that. And he said, at the time of the interview, and when you take the entire interview in context, as opposed to picking out lines here and there, he said, the timing suggests to me that protamine might have had an involvement. The patient appeared to be stable enough that I could decannulate and recover the patient. Protamine was applied, and then at some point in the course of treatment, the patient crashed. So maybe this intervening event might have had some impact. Then the final issue with respect to patient LK is ischemia. And on this one, this is not a he said, she said. This is fairly simple for the members of the panel to look at the record and come to their conclusions. The allegation in the accusation was that Dr. Lin failed to diagnose ischemia in patient LK's leg prior to patient LK's discharge from the hospital where Dr. Lin was treating him. The patient was post-op from the mitral valve replacement and needed to be transferred to another facility that could better handle his care, that could handle the next steps in his care. So the patient was going to be leaving the hospital where Dr. Lin was treating him and leaving Dr. Lin's care. The testimony and the evidence that is unrebutted is that this patient left Dr. Lin's care without any signs of ischemia which required intervention. It's important that you understand how I qualified that. Status post bypass surgery, or where they've been on a bypass machine for mitral valve repair or replacement, are basically put on support. And in that instance, there are a lot of signs and potential risk factors associated with ischemia. Dr. Lin testified to this at the time of the hearing. So what does he do? He makes sure that he's checking on the patient and that he is ensuring that the patient does not leave his care with ischemia. And in fact, the medical records support the fact that ischemia wasn't found until much later after the patient arrived at the receiving facility. So I would encourage you to take a look at these three issues that I've highlighted. The absence of a nexus between the claimed mistakes and his competency to practice medicine. The lack of clear and convincing evidence of a lack of competency, including, frankly, the lack of evidence from any recipient witnesses about a lack of competency. So that is, people have actually seen or experienced a lack of competency on Dr. Lin's part. And consider the best evidence of competency, which are, frankly, the words out of Dr. Lin's own mouth and from his character witnesses. Thank you.
Thank you. Mr. Davis?
Thank you. Good morning. The proposed decision in this case correctly sustains the sole cause for discipline in the accusation, which is that Dr. Lin exhibited incompetence in his care and treatment of both patients GR and LK. The term incompetency generally indicates an absence of qualification, ability, or fitness to perform a prescribed duty or function. That's a definition from Curl v. Board of Medical Quality Assurance. In the Curl case, the medical board brought a disciplinary proceeding against an anesthesiologist, charging him with, among other things, incompetence in the anesthesia of one patient. After an administrative hearing, the board upheld the findings that the physician demonstrated a general lack of knowledge, ability, and skill in anesthesiology, despite the fact that he'd worked on over 20,000 cases. The Court of Appeal upheld a denial of the physician's writ of mandate, finding while one patient was involved, there were several acts or decisions by petitioner which were improper. This suggests more than a single honest failing in performing his duties. Like the physician in Curl, respondent committed multiple acts involving two separate patients that clearly evidence that he demonstrated a lack of knowledge. With regard to patient GR, as counsel pointed out, he was undergoing a mitral valve repair and replacement procedure using the Da Vinci robotic system. During the procedure, the operative field began to fill with blood. Now, respondent was asked about that during his medical board interview in June 28, 2010. And he was asked why he thought the operative field was constantly filling with blood. In response to that question, the respondent stated as follows: "So my explanation is because he had multiple pulmonary emboli, so the pulmonary artery is blocked with clot. This may be pre-existing already. He had already had this, and we could never detect detect it before surgery. There is no way you can diagnose before surgery. So that is why there's a lot of venous drainage pile up in the chest. That was his exact comment. There was only one expert witness that testified in this case, and that was complainant's expert, Dr. Lamar Bushnell. And he testified that there are many clinical diagnostic measures to disclose the presence of pulmonary emboli. Those measures, as Dr. Bushnell testified, include radiographic tests, EKG findings, echocardiographic findings, pulmonary measurement findings, and oxygen saturation measurements. Dr. Bushnell noted in his testimony that none of the clinical findings in this case supported the existence of pulmonary emboli in patient GR. Dr. Bushnell also discussed that patient GR's well score, which is a score that is essentially it's a clinical score to help calculate the probability of the existence of pulmonary emboli. And as Dr. Bushnell testified, the well score is calculated on an 11-point scale with a score of 4 or over indicating the existence of pulmonary emboli. In this case, patient GR's well score was 0. And that is in the transcript of Dr. Bushnell's testimony. Dr. Bushnell also authored a report concerning his opinions about, concerning respondents' opinions about GR's venous drainage, and he stated as follows: respondents' assertion that the patient had preoperative severe pulmonary emboli and that such a condition could not be assessed preoperatively, and that this condition, should it exist, was likely responsible for his problems with venous drainage, all indicate a lack of knowledge. And notably, Dr. Bushnell went on to observe that such a lack of knowledge is concerning, as such knowledge is critical to the surgeon's ability to deal with intraoperative complications, evaluate likely etiologies of those complications, and subsequently adjust techniques and procedures to prevent such complications in the future. It is clear that the respondent's reliance on his explanation for the venous drainage was not supported by any of the medical records, and in the opinion of the only expert that testified, exhibited a lack of knowledge. Now, with regard to patient LK, again, as counsel pointed out, he was undergoing a mitral valve repair and replacement procedure. And after the procedure and after he was taken off the bypass machine, his condition deteriorated significantly. He began to experience biventricular dysfunction and myocardial infarction. Now, a respondent in his interview stated that the biventricular dysfunction and myocardial infarction were due to a reaction to protamine. Again, at hearing, Dr. Bushnell was the only expert to address this issue, and he testified that the respondent's attribution, the protamine caused patient LK's severe heart dysfunction, was essentially physically impossible because patient LK was on full support before the protamine was given and was still experiencing heart dysfunction. Dr. Bushnell further testified that protamine itself would be very unlikely to be the etiology of patient LK's biventricular dysfunction and myocardial infarction. Interestingly, Dr. Bushnell said, before the protamine was even administered, this patient, and I quote Dr. Bushnell, was about as far south as you can get. Dr. Bushnell again authored a report concerning this issue, and he indicated that Dr. Lynn's assessment of the cause of the patient's severe postoperative biventricular dysfunction with regard to that, concerns exist. The intraoperative records indicate that there was a severe myocardial dysfunction after removal of the cross clamp for a considerable period of time before the administration of protamine, such that increasing titration of high doses of multiple pressors was required. This preceded the administration of protamine and indicates the protamine was not the cause of the myocardial damage and dysfunction. Dr. Bushnell ultimately opined that respondents' persistence in attributing this problem to protamine reaction indicates a lack of knowledge. With regard to the lower right extremity and the ischemia, during the medical board interview and at the hearing, respondent maintained that patient LK did not have lower right extremity ischemia upon his transfer to Sharp Memorial Hospital. Respondent's transfer summary notes indicated that at the time of his transfer on December 17, 2008, the patient's hemodynamic condition was maintained on inotropic support with CPS support and extremities. In other words, this had been going on a long time by the time the transfer team got there. It's further noted in the assessment section of the transfer team that patient LK has evidence of distal ischemia of his lower extremity of questionable reversibility. Again, this indicates that that was there for a while, and that respondent missed it. Dr. Bushnell opined that that again indicates a lack of knowledge. In short, the clear and convincing evidence in this case, as held by the administrative law judge in this case, indicates the opinions of Dr. Bushnell again support that respondent exhibited a lack of knowledge in the care and treatment of patient GR and LK. Now, as to appropriate discipline, the proposed finding in this case recommends a public reprimand in PACE. The medical board's disciplinary guidelines in a case such as this call for a minimum of 5 years probation. The problem with no probation in this case is that we've got 3 incidents where the doctors exhibited a lack of knowledge. We don't know where that lack of knowledge ends. What other areas does he lack knowledge in? The only way to assess that is, 1, through PACE, and again, to monitor him over a period of probation. It's the only way that public protection can be obtained. So based on that, I would ask that the board find that the ALJ's decision regarding the causes of action be sustained, and that the board order revocation stayed, 5 years probation with PACE and PACE records keeping and all standard terms and conditions. Thank you very much.
Thank you. Mr. Riffin?
Members of the panel, I don't want to overstate Dr. Lynn's reputation, but the unrebutted testimony at the time of the hearing of this case from his peers, as well as from Dr. Lynn's explanation of his background, his expertise, his experience in the field of cardiothoracic surgery, all point in unrebutted fashion to the fact that Dr. Lynn is one of the most preeminent cardiothoracic surgeons in San Diego, period. His competency is not in doubt. The record in this case reveals that. And just very quickly, let me touch on what the Attorney General said. In terms of the venous drainage issue with patient GR, when you take a look at the entirety of the record, you find that Dr. Lynn told the investigators at one point during his interview that he didn't know the cause of the venous drainage. But the investigators persisted and asked him to speculate, and so he offered a potential explanation and explained why that was within the realm of possibilities as opposed to probability. Counsel speaks of multiple acts demonstrating the lack of knowledge. There are no multiple acts demonstrating the lack of knowledge. There are answers given in the context of an investigatory interview that are being selected. And an expert's opinion, frankly, is only as good as the facts that expert relies on. In this case, Dr. Bushnell, testifying on behalf of the petitioner, basically selected key phrases out of the course of a more than an hour-long investigatory interview that he believed demonstrated incompetence, and admitted that he excluded from his consideration those statements that contradicted the ones that he said were just wrong. With respect to protamine, Dr. Lynn said in the context of his investigatory interview that he thought it might not be a problem, or might not have been the cause of the patient's decline. But again, invited to speculate, he offered that as a potential explanation. And then with respect to ischemia, I think this is where, and I argued this with the administrative law judge below, this is the area where I have the most concern in terms of being able to persuade you. The issue is, well, did he know enough to diagnose ischemia before the patient left his care? If he had diagnosed the ischemia, he could have addressed it immediately and saved the patient's limb, potentially saved the patient's life. Well, I think it's important to look at the facts. It's important to look at the context. And counsel has indicated what those facts are. A physician from the receiving facility sat with the patient for 3 hours. Basically, what counsel is suggesting is that that physician, along with Dr. Lynn, along with the ICU team and the other nurses attending to the patient, basically ignored marked or apparent ischemia. I think that's just absurd on its face. It's certainly not clear and convincing evidence that Dr. Lynn demonstrates a lack of confidence. He is, as I said, the leading surgeon, or one of the leading surgeons in this field in San Diego. Any discipline, including a public reprimand, is inappropriate on the facts of the case, but beyond that, and I know members of this panel are very well aware of the consequences of discipline. Discipline in this case against Dr. Lynn would have a devastating impact, not just on him, but on his availability to the patients he serves. As you know, peer review proceedings, re-credentialing decisions, credentialing with third-party payers are all influenced and significantly impacted by discipline, no matter how slight in a case like this. And I think given the circumstances of the case, that is, a practitioner basically being deposed and cross-examined in the context of an interview, even though it is not a deposition and it is not an opportunity for cross-examination, poses a potential, poses a troubling issue. The case of Pearl that counsel has cited in his briefing and in his argument deals with the actual rendition of care. Basically, what counsel is asking this panel to do is to set new precedent, to say that a doctor, in the context of an investigatory interview, if he gives incorrect answers or inconsistent answers with respect to other answers that he's been given when asked hypotheticals, then he ought to be disciplined. And with that, I submit. Thank you.
That was 1 minute sign, not a stop sign.
I always like to finish early.
Okay, thank you. All right, Mr. Davis, your
Thank you. Just
rebuttal.
briefly. Counsel talks about the reputation testimony establishing that there's not evidence of lack of knowledge here. There's a big difference between reputation testimony and expert testimony. The reputation testimony that was offered into evidence by Dr. Lynn at trial were from colleagues who had not reviewed the transcript of the board interview or the records in this case. They were coming in and talking about the guy they know, the guy they've worked with. The expert, on the other hand, evaluated all the records, including the transcript of the interview, and came to his conclusions based on the actual evidence, rather than on some subjective standard based on who he knows. And also, respondent argues that he was offering potential differential diagnoses at his interview. Well, there's a big difference between potential answers and explanations and impossible ones. Again, Dr. Bushnell clearly testified that his reasons and his analysis of the venous drainage and the protamine issue were impossible and contrary to what a medical doctor and cardiothoracic surgeon should know. Giving potential differential diagnosis is fine as long as they're reasonable, but when they're impossible, they exhibit a lack of knowledge. With regard to the ischemia issue, the transferring physician did not address the issue. He documented what the condition was of the right lower extremity, and when he got to the transferring hospital, they began vigorously treating it. Ultimately, they were unsuccessful, and an amputation had to be done, but there wasn't any lapse of care on the part of the transferring physician. Now, with regard to discipline, the board's primary goal is public protection. In every case where probation is ordered, there's potential collateral consequences, but those cannot outweigh the board's duty to protect the public. The ALJ in this case noted, and this is a reason why probation is important, he noted at page 9 of his proposed decision that during the hearing the respondent had a certain degree of difficulty in expressing himself, and the respondent's answers during his testimony revealed that he had difficulty staying focused on the exact question asked. That's demeanor evidence that the ALJ saw that aided him in coming into his conclusion. So again, I would ask that the board impose the discipline previously recommended by the complainant. Thank you very much.
Thank you, Mr. Davis, and thank you to both counsel. And now, Dr. Lin, it's your opportunity to address the panel directly if you would like to.
Thank you. I'm Dr. Lin. Since 2003, the California coronary artery bypass grafting surgery outcome result become public. It is published in Archibald website. The most current report revealed that there were 289 surgeons from California participated, and I have performed 386 cases in the report, the third highest in California. My outcome was excellent. However, member of the board, I have to tell you that I'm humbled by this process. I am intimidated by today's hearing. I would like to have opportunity to convey to you that why I should not be disciplined with this case. First, I'm not incompetent. I'm considered the leader of cardiac surgeons in San Diego. My record includes 2,000 successfully performed minimum invasive cardiac surgery. Second, my care to this patient was attentive and superb. It is unfortunate the patient did not survive from the surgery. In the last 4 years, I spent tremendous time seeking for answers, and I had learned a lot from this. Third, the reason we are here today is because of my failure, not failure in competence. I failed to make myself clear and understood at the time of medical board hearing. I take responsibility for it. I'm very sorry about it. I had fortune to receive the best surgical training at Mayo Clinic. Our goal in cardiac surgery was to achieve 0% mortality. It is very uncommon for me to lose these two patients. I have vivid memory of the patient and their family. I give family daily report after surgery. I talk to Mrs. GR 3-4 times every day. Mr. GR died 1 week after surgery. I ordered the autopsy and participated in the post-mortem examination. I arranged multiple family meetings. I met with her family member on numerous occasions. I felt great empathy to the family member. The cardiac surgery always associated with some degree of injury to the heart. We use myocardial protection to minimize the heart damage. Along with myocardial protection and pharmacological management, we were able to improve our surgical outcome. The mitral valve surgery mortality rate is 10%. Toward the end stage of the Mr. LK's surgery, we anticipate myocardial injury. We started treating, and by giving him more time and administer more medications, gradually he improved. Just like every other cardiac cases, slowly he became more stabilized. We terminated the cardiopulmonary bypass machine and watched him for 36 minutes. Finally, we moved to the last stage operation by giving him protamine to neutralize heparin and closing the chest. Suddenly he crashed, and we had to put the heart-lung assist device back to him. The decision has to be made immediately, and the procedure had to be executed right away. And it was not a time to make differential diagnosis of drug reactions. At the time of board interview, there are many questions raised about the last stage of these operations. Why did he crash? There were no easy answers. The procedure was done properly, and myocardial protection was delivered properly without any mistake. And at that time, I was in the midst of litigations. One of California's leading experts in pharmacology and anesthesiologist, Dr. Richard Ruffalo, had made a explanation about possible protamine
Your Honor,
reaction.
I'm going to object. We're starting to get into additional evidence here, and that's not proper at this proceeding.
Yes, I understand, Mr. Davis. Now, I'm just sitting here thinking whether I should interrupt Dr. Lin. Now, I really apologize, Dr. Lin, but the opportunity you're provided today is really to address the terms of the penalty. And you've spoken a lot about your feelings about how the procedures went and things like that. But the board isn't able to take any evidence today, and I think that the main problem with allowing you to go on too long is that you might be under the impression that they can consider what you're saying really as evidence, not just in your speaking to the penalty. Do you understand?
Yeah, let me say my final words.
Thank you.
I came to the board investigation meeting with the belief that it is a time for collaborations. And I believe it was not a time for deposition. And I was truthful, straightforward with the board member. And the only limitation at the time of board meeting is I could not speak like a lawyer. I had difficult time sometimes to choose my words to say properly. And in summaries, I would like to tell the board member that I'm fully responsible for the care of this patient. I'm deeply sorry for their death.
Thank you very much. That will conclude the oral argument and this proceeding. We're off the record, and ask everyone, the public members or the public folks, to leave so that the board can consider their decision. Thank you.
This is the Enforcement Committee and of the Medical Board of California. I'd like to introduce some new members. Mr. David Sewell.
You gotta go back to the office.
He's not here. And who's the other one? Barbara. You need no introduction. Barbara Yaroslavsky is the other new member. Okay, so can we have roll call, please?
Dr. Lanadev? Here. Dr. Lowe?
Here.
Dr. Levine? Here. Ms. Shipsky? We have a quorum. Oh, Ms. Yaroslavsky? We have a quorum.
Okay, so the first order of business is that we will take public comments on items not on the agenda. If you would like to speak, please hand the speaker slip to Renee Threadgill, who's there, and she'll bring it up to us, and we'll be glad to entertain your comments. Our first speaker is Steve Katolika from the California Society of Physical Medicine and Rehabilitation. So please, I think we'll have 3 minutes for your comments.
I should be shorter than that. Thank you, Chairman Lowe, Dr. Levine, the other board committee members. My name is Steve Katolika. I'm the Director of Government Relations for the California Society of Physical Medicine and Rehabilitation, the California Neurology Society, as well as the California Society for Industrial Medicine and Surgery. Members of these organizations are physicians licensed in California, most of whom are in solo or small group practices in their various subspecialties. Since 2008, our clients have introduced legislation that would establish that utilization review physicians must be licensed in California before providing such reviews. We did so out of concern for patient safety, as well as to establish in law what we believe is the obvious, that you, our physicians, should be held accountable for the effects of their decisions on often faceless patients. Throughout these legislative efforts, we've welcomed the support of this board's policy that utilization review is, in fact, the practice of medicine. And despite vetoes by then Governor Schwarzenegger, as well as current Governor Brown, the merits of our argument for accountability have never met with any argument based in law, medicine, or health and safety, but rather political stonewalling and various insurer-based business concerns. The failure of both administrations to recognize the core issue of safety and accountability most recently came to roost when we learned that a patient was cut off cold turkey from opioid therapy by a California licensed utilization review physician who was representing a workers' compensation insurance company, and subsequent to the severe withdrawal issues, landed in the emergency room. We also learned that the board may have decided that it has no jurisdiction over these licensees in this type of situation. And if this is accurate, we're disheartened. First of all, for the patients who may be adversely affected by UR physician decisions, but also because we fully intend to reintroduce language to require California licensure for all UR physicians. We would be dismayed if we did not have the support of the board's policy and jurisdiction. The situation with this particular patient is not uncommon, nor is it going to resolve itself without severe repercussions. Especially where opioid therapy is involved, UR decisions made in a vacuum of accountability present a problem of growing proportions. So we would ask that the medical board place the issue of utilization review as a practice of medicine and the board's jurisdiction over licensed utilization review physicians on the agenda for your next meeting, which I understand is going to be held in April. Thank you.
Okay, I appreciate your comments. Our next speaker is Yvonne Chong from the California Medical Association.
Good afternoon. Yvonne Chung with the California Medical Association. We'd like to support Mr. Katalika's comments on behalf of the Society for Physical Medicine. Just a couple additional points. We too would like to see this item on the next agenda for the Enforcement Committee and for the Medical Board itself. We agree with the Medical Board's previous position that a decision to delay, modify, or deny medical treatment does constitute the practice of medicine and that the board has jurisdiction over this act. We'd like to just find out some more information about how the board intends to enforce this position. And really we see this as three issues that need further clarification. One, whether UR is indeed the practice of medicine, which we believe it to be, whether the board has jurisdiction, and most importantly, what policy or resource changes would need to be made in order to provide the resources that would allow the board to fully investigate these types of violations. So we would support having this item on the agenda of a future meeting. Thank you.
Thank you so much for your comments. Our next speaker is Tina Manassian from the Consumers Union Safe Patient Network.
I'm actually talking on an item that's on the agenda.
Okay. Sorry. Okay, so we'll move on then. Are there any other people that want to speak on the public comment portion? Okay, none. We'll move on to the next item, approval of the minutes for the July 2012 meeting. May I have a motion to approve the minutes?
So moved.
Is there a second?
Second.
Any discussion? Comment? All those in favor of approving the minutes? Aye.
Aye.
Any opposed? Okay, minutes are approved. Okay, we'll have an update on the expert reviewer training from Ms. Sweet. Ms. Sweet, would you like to give her your presentation?
Good afternoon. I wanted to let you know the status of our second expert training, which is going to be held a week from Saturday on the 9th of February at UC Irvine. We've had an overwhelming response. In fact, we're overbooked by 7 individuals at this point, and people have been begging to be able to attend. So that's very heartening. And we have, this time around, have made a couple modifications to the training. We have allocated 2 additional CME credits for a total of 10 credits for each participant, because they're going to be preparing a sample expert opinion that's going to actually be graded. So we're excited about that. We have teams put together of a supervising Deputy Attorney General, supervising investigator 2, and a medical consultant who will grade the actual opinions to make certain that the training is being heeded and the training is effective. So we are very excited about that, and that pretty much concludes the update. Are there any questions?
You know, I certainly want to commend you for this program. I think it's one of the best things that we've done in terms of trying to raise the bar for our experts and making it uniform across the state. And I had the opportunity to attend the first one, and it was really outstanding, and the feedback was outstanding, and the experts were enthused and excited about what they had learned. So I think this is a wonderful program, and hopefully we can extend it to maybe medical consultants, maybe to the investigators and so forth in the future, because you can always benefit from more education. So thank you for all those efforts.
Well, thank you for your leadership, Dr. Lowe.
Dr. Lowe, before
Yes.
you continue, I wanted to thank you as well for your leadership on that issue, and wanted to ask, what is the makeup of the experts that are coming? Are they currently experts that
Yes.
are experts, or people that want to become experts?
They are current experts. And so we're also going to be using this sample opinion as kind of an opportunity to see if some people are matched well in our expert program. So if we can't remediate, so it's an opportunity for us to decide if a particular individual is appropriate for the program.
So will it get to the point that in order to be an expert reviewer for the medical board, you will have to have attended one of these trainings?
That would be ideal.
Thank you.
There are already there's a lot of requirements to become an expert already, and they already have a huge arsenal of material to train those people to be experts. But many times we're not sure that they understand all that material, but this session helps drive it home.
Exactly.
So I know you missed the last one, and if you have the opportunity, it's going to be next Saturday in Orange County, not too far from Los Angeles.
Just an hour's drive.
Okay, good.
Close enough.
But it's like another country, they tell me.
It is. You have to get a passport.
Okay, are there any public comments on this issue? Okay, we'll move on to the next agenda item. We're going to deal with the Central Complaint Unit Progress Report from Ms. Katie.
Thank you. In July, I gave a presentation to this committee on the Central Complaint Unit, and we had identified some goals that we had for improving the case aging. At that time, the average number of days that were required to process a complaint in the complaint unit averaged around 80, from 83 to 85. Since that time, the complaint unit has been successful in reducing the average number of days by about 20, primarily by focusing on shortening the time frames associated with obtaining an initial medical consultant review. So I wanted to go through some of the things that we have done. New consultants have been identified, so we've recruited and added to our consultant pool, which has allowed us to reduce the wait time, so to speak, in assigning a case to a consultant. So by adding additional consultants, we've been able to reduce the number of days a case sat on the shelf waiting for assignment to a consultant from about 30 down to 7. With these additional consultants, now we've been able to reduce the number of cases that we would assign to each consultant. So instead of sending them 5 cases to review, we never send them more than about 2. So this allows for a quicker turnaround time as well. The staff are now following up. We still are allowing our consultants 30 days to review cases, but they're following up usually in 3 weeks to confirm that they're getting close to being done. Again, with the reduced number of cases going, they're usually returning cases well within that time period. The other tool that we've added that's been really helpful is we now have a contract for medical transcription services. So in the past, our medical consultants either hand wrote their reports or they typed their reports because we didn't have any mechanism for dictating and transcribing. So now we have a toll-free dial-in dictation or call-in dictation line, and the consultants can use that dictation line for the report. So that's also increased or allowed them to turn around the cases much faster. One of our other goals that we had identified was to reduce the amount of time required for case initiation from 10 days down to 5 days, and we have been successful in doing that as well. These efforts, in combination with the work of all of the managers in following those troublesome cases and responding to them quickly, have allowed us to significantly drop our average case aging time and meet the goals set in the strategic plan. Any questions on this presentation?
Well, I personally want to thank you and the CCU for your contribution to improving the efficiency and quality of our whole process, and I think hopefully we can get that same effort from every other section so we can be a lot better.
Thank you, Dr.
So are there any questions from the board members?
Mm-hmm.
Yeah, I'm still wondering, why do we need 30 days for the medical consultants to respond? I mean, that's pretty long time.
It is a long time, and that's another area that I think that we can carve out a few more days. Like I said, 30 days, depending on the practice specialty. Sometimes we have difficulty finding experts in particular practice specialties, and neurology is one that's always difficult. And so if we allow them up to 30 days, we can still keep the cases moving. I would say that the majority of our consultants do not use that 30 days, especially when they're only reviewing 1 or 2 cases. But that is an area that we could carve out a few more days, I believe.
Yeah, I think we definitely need to encourage them to get it in within 2 weeks.
Yeah.
When you give them 30 days, they still wait until the end anyway, so you might as well just tell them up front, we want it now.
Right.
And if they can't do it now, we'll use somebody else.
Right.
Okay, are there any public comments on this agenda item? Okay, moving on, Ms. Katie, please remain and give us the update on the SB 1441 implementation. Please explain what it is first as a background, and then go give us the progress update.
SB 1441 required that the Department of Consumer Affairs establish a uniform standards regarding substance abusing licensees. So DCA developed the uniform standards, and those have then I'd like to report on how the medical board has incorporated those guidelines and is utilizing the guidelines developed by DCA. If you'll turn to agenda item 6, I've attached a chart that identifies each of the 16 standards that were developed by Consumer Affairs. Approximately half of those standards relate to boards that have an existing diversion program, so those standards did not apply to the medical board. But within those uniform standards, there were kind of 2 general areas that the remaining standards fell into, and that are focusing on 2 main areas. One is sort of intake. How do we handle the licensee as they come into probation? And compliance, and how do we monitor that they're complying with those standards or with those guidelines. Uniform standard number 1 states that the licensees must undergo a clinical diagnostic evaluation and must comply with any recommendation for treatment or practice restrictions. Under our current and disciplinary guidelines, when a physician is placed on probation for a substance abuse issue, usually a psychiatric evaluation and a medical evaluation are always ordered, and those conditions can be ordered as a preceding condition, meaning that the physician would be suspended until those evaluations have been completed. And, this is consistent with the standard developed by the Department of Consumer Affairs. The probation unit uses experts that have addiction medicine specialties or expertise to perform those initial assessments. And again, that's consistent with the guidelines developed by the department. Our standard language also allows the board or the probation unit to order another evaluation anytime it's deemed necessary. So if we have some concern about a physician, we can certainly order them to undergo another evaluation. The uniform standards number 2, 4, and 8 through 10 sort of focus on monitoring the probationers or the physicians on probation for compliance. Biological fluid testing is started as soon as a physician is placed on probation, and the probation unit does use the testing frequency that's recommended in DCA's uniform standard number 4. If a physician tests positive for a banned substance, the board has the authority to issue a cease practice order for 15 days, which is consistent, again, with the department's standards for removing the physician or the licensee from practice. DCA standards number 9 and 10 address a penalty or ask to identify a penalty for testing positive, or that should be contemplated for a positive test. What the medical board has opted to do instead of identifying a penalty is refer the matter, when there's a positive test, to the field for a formal investigation. And after that, the circumstances of the positive have been investigated, then a determination can be made whether the facts of the case warrant either pursuing an ISO or pursuing disciplinary action. That concludes my presentation. Are there any questions about how we've implemented these standards?
We'll entertain questions from the board. Ms. Yaroslavsky?
Yeah.
So what is the time frame that's allowed? What's missing from all of these conditions of implementation are how long, what's the wiggle room, what's the expectation of when you're going to, how many things does a person have to miss before you're on the phone wondering, stopping practice? What is the process?
There's a couple of different circumstances that could arise during probation, and one might be that the physicians are required to call in. If they're on biological fluid testing, they're required to call in to the First Lab, is who we have our contract with, on a daily basis. So we are able to see instantaneously, or we check daily about whether they've called in. Is there a reason for them not reporting? Is it a scheduled vacation? Is there some reason why? So we can get on those cases fairly quickly in terms of missed calls. If there's been a positive test result, one of the first things we have to look at is that positive test related to a lawful prescription that's been given to the physician. So we look at, do we have any record of what medications that doctor's on? Is the positive test related to that? Because there are certainly some of the tests that require a physician continue to comply with medication. If there's no explanation for the positive, we initiate a case and we send it out for investigation immediately.
So let me be more clear.
Sure.
Because that's not enough information for me.
Sure.
So within the first disciplinary guideline here, a medical and psych eval has to be obtained and allowed the board to designate an evaluator. What's the time frame that's going to take place? And I mean, nothing's stated, and I understand that you need some, but what is the expectation of the public? What's the time frame going to be?
All of the time frames for all of these conditions are in the disciplinary guidelines, and typically the evaluation has to be done. I don't have guidelines in front of me, but typically it has to be done within the first 30 days of probation. So all of those expectations for timelines are codified in the disciplinary guidelines.
Okay, thank you.
Yes, Dr. Guanada.
Skady, I'm looking at item 10. It says basically the guideline from DCA is that licensee must cease to practice and obtain another clinical evaluation and so on and so on.
Correct.
But when I see we are authorized to do, but we have a policy of referring to AG's office for the disciplinary action versus so on and so on. So how often do we use the cease practice, or do we rely on the AG's office?
We have what our disciplinary guidelines allow us to do is issue a cease practice order, and the time frames are identified again in the disciplinary guidelines. So we can issue a cease practice for 15 days, and after that it's similar to the time frames for an ISO. So we have to have an investigation. We have to be prepared to go forward to request an ISO within that 15 days. Again, it's difficult when you get just strictly a positive test to confirm that this is a legitimate relapse versus there may be some explanation. So we do try to rule out any false positives before we take the steps of pulling a physician out of practice.
Yes.
So just to clarify,
the cease practice requires no judicial involvement.
That's correct.
The ISO within 15 days after a cease practice, the board has to be prepared to go to the judge for an ISO to continue keeping someone out of practice. Is that correct?
Within a given year, could you give us an idea of how many, within a given year, could you give us an idea as to the numbers that you've had to do within each area, either the ISO or the stop practice?
The disciplinary guidelines that authorize the cease practice order just went into effect January 1st, so we don't have a lot of history in terms of how that's going to play out. We have not, to the best of my knowledge, initiated any cease practice orders based solely on the positives yet.
Okay, any other questions from the board members? Okay, we're going to move to public comment. Our first speaker is Tina Manazian, Consumers Union Safe Patient Network.
Good afternoon. I'm here on behalf of the Consumers Union Safe Patient Project, a nationwide campaign that is organizing patient safety advocates from across the state of California as the California Safe Patient Network. Substance abusing physicians pose significant risks to patients who typically are unaware of the problem. When these issues come before the medical board, they should be addressed through a comprehensive and predictable process that is publicly transparent and has integrity. In 2008, the legislature passed and the governor signed SB 1441, establishing the Substance Abuse Coordination Committee within the Department of Consumer Affairs. In April 2011, the committee finalized the SB 1441 uniform standards regarding substance abusing healing arts licensees uniform standards to be used by all of the California's healing arts boards in addressing substance abusing providers. When some began questioning whether the healing arts boards were required to follow the standards, the Legislative Council Bureau, the Office of the Attorney General, and the Department of Consumer Affairs each issued opinions unequivocally stating that the standards are mandatory. They must be used by the healing arts boards. Despite this, the medical board has not yet adopted the full uniform standards. The medical board did undertake a rulemaking process to adopt standards related to substance abusing physicians and incorporated some of the standards into the Medical Board of California Manual Model, Disciplinary Orders and Disciplinary Guidelines, 11th edition 20011 guidelines, but these were not the full SB 1441 uniform standards. As you know, medical board staff prepared a chart for today's meeting related to the board's implementation of the uniform standards. The chart briefly identifies the 16 standards and goes on to comment on each of them. In some cases, staff is saying that a standard is not applicable because it relates to licensees in a diversion program. Similarly, a brief discussion of this issue in the Medical Board of California Sunset Report 2012 on page 132 says, and I quote, "The board's diversion program was eliminated in 2008. Therefore, 8 of the 16 standards relating to monitoring licensees in a recovery or diversion program were not applicable. The law is not ambiguous about this matter. SB 1441 was explicit that these are uniform standards, and the lack of diversion program is not an acceptable excuse for not implementing the standard. Section 315C of the Business and Professions Code says that there are uniform standards, and I quote, that each healing arts board shall use in dealing with substance abusing physician, whether or not a board chooses to have a formal diversion program. This is California state law now. It is not within the discretion of the medical board to fail to implement the uniform standards. While we did not undertake a comprehensive word-by-word comparison between the uniform standards and the board's guidelines pertaining to substance abusing physicians, we have noted many important requirements in the uniform standards that are missing from the medical board's guidelines. The following are some examples of requirements in the uniform standards that we believe are important but do not find it in the medical board's adopted guidelines. I have 9 examples here. In the interest of time, I will only read 2, but if the board would like to hear more now, please let me know. A requirement that the board order the licensee to cease practice during a clinical diagnostic evaluation pending the results of the evaluation and a review by the board, uniform standard number 2. A requirement that while awaiting results of a diagnostic evaluation, the licensee be randomly tested at least 2 times per week, uniform standard number 2. a requirement that no licensee be returned to practice until he or she has at least 30 days of negative drug tests, uniform standard number 2. A requirement that, with a few explicit exceptions, when the licensee is on probation, a minimum range of random tests is required, 52 to 104 in year 1 and 36 to 104 in the second year of probation, and each year thereafter up to 5 years, uniform standard number 4. A requirement that the licensee make daily contact to determine whether drug testing is required, uniform standard number 4. A requirement of specific training or certification of specimen collectors, and a requirement that specimen collectors adhere to U.S. Department of Transportation specimen collection guidelines, uniform standard number 4. A requirement that laboratories be certified and accredited by the U.S. Department of Health and Human Services, uniform standard number 4. A requirement that in the case of a group support meetings, there be restrictions on financial, personal, or business relationships between the meeting facilitator and the licensee, uniform standard number 5. A requirement that the licensee demonstrate explicit criteria, including 3 to 5 years of continuous sobriety, to request a full and unrestricted license be reinstated, uniform standard number 12. We urge you to come into compliance with the requirements of SB 1441 and implement the full uniform standards immediately. Thank you.
Okay, our next public comment is from Julie D'Angelo Felmuth from the Center for Public Interest Law.
Good afternoon, Dr. Lowe and members of the committee. Julie D'Angelo Felmuth from the Center for Public Interest Law. I agree with what Ms. Manassian and Consumers Union have just said. Despite what this chart appears to say to you, the medical board has not properly implemented the uniform standards that, in the words of Business and Professions Code Section 315, each healing arts board shall use in dealing with substance abusing licensees, whether or not a board chooses to have a formal diversion program. Yes, the board did amend its disciplinary guidelines regulation, which is Section 1361 of your regulations, in 2011, but the board's approval of that regulation came in January of 2011, before the uniform standards were even finalized in April of 2011. So you could not possibly have adopted the full and correct version of the uniform standards. And Section 1361 only refers to the board's disciplinary guidelines, which are discretionary. It does not refer to the uniform standards. No medical board regulation refers to or incorporates the full uniform standards. And Section 1361 says that deviation from disciplinary guidelines is appropriate in the discretion of the board. That may be true, that is true for disciplinary guidelines, but it is not true for the uniform standards, which, as Ms. Manassian said, 3 different legal opinions have concluded are mandatory. They must be used. I concede that there has been a lot of confusion about whether and how the uniform standards should be adopted, but there is no confusion about 3 things. First, the department director has directed all healing arts boards to adopt a regulation that clearly requires each board to use the uniform standards in mandatory fashion when dealing with a substance abusing licensee. 2, she even suggested, and we agree with this suggestion, that the regulation requiring use of the uniform standards in substance abuse cases be separate from the board's disciplinary guidelines regulation. And third, the medical board has neither adopted such a regulation nor properly incorporated into its disciplinary guidelines all of the uniform standards and required the board to use them when dealing with substance abusing licensees. This chart accurately quotes the uniform standards on the left side, but the right side, which indicates how the board has implemented each standard, is replete with citations to board policies and optional terms of probation, and we are allowed to do this, or it's our practice to do that. None of those are mandatory. None of those are enforceable. None of them require this board to do anything. SB 1441 applies, as you have heard, to all healing arts boards, regardless of whether they have a formal diversion program for substance abusing licensees. This board has not properly implemented the law's requirement that it use the uniform standards in mandatory fashion, nor has it incorporated all the uniform standards into its disciplinary guidelines and required their use. We urged the board to initiate a rulemaking process to adopt a new regulation separate and apart from that discretionary disciplinary guidelines regulation, section 1361, requiring the use of the SB 1441 uniform standards in substance abuse cases. Thank you.
I appreciate your comment. Are there any other, is there any other public comment? Okay, being that there's none, we'll move on.
Wait, you have.
Good afternoon. I'm Doretha Johnson, Chief Counsel and Deputy Director for Legal Affairs at Department of Consumer Affairs. I just wanted to take a moment to reiterate what was stated by the two previous speakers. The Department of Consumer Affairs agrees with respect to the fact that the implementation plan that has been proposed by the Enforcement Committee of the Medical Board does not take into consideration the mandate that was placed on the department and on each of the healing arts boards. The SB 1441 standards apply to all of the boards. They're mandated, and the application through the implementation plan that has been proposed does not take that into consideration. As was stated by the two previous speakers, there was a great deal of confusion at the inception of this implementation or of the passage of SB 1441. In an effort to mitigate that confusion, a request for legal opinion was proffered or requested by both the alleged counsel, and we did not stop there, but we also requested an application or an opinion from the Attorney General's office. That opinion, which was consistent to the extent that it said that it was mandated that the language of 315 was a requirement on the department's boards, on the medical board, and all of the other health boards, that the standards be applied across the board uniformly, and that was the purpose of it, so that it would be a uniform application. That has not been done by the medical board. And we understand that they took the action that they did with regard to the disciplinary standards prior to the completion of the process by the committee. But after that, there was an expectation that they were to go back and amend their disciplinary guidelines and proper regulations that fully implemented the full expectation and purpose and the mandate that is set forth in SB 1441. And to that extent, we are requesting that this matter be referred back to the Enforcement Committee so that they can promulgate regulations that fully implement the standards set forth in SB 1441. Thank you. Are there any questions?
Nope, you're quite clear. We appreciate your comments. So moving on to the next agenda item, do we have any agenda items for the May 2013 meeting in Los Angeles area?
Wait, what's the question?
This agenda items for the next
Oh,
meeting.
yeah. I'm sorry. I'm still stunned by the last presentation.
So certainly we're going to incorporate into that agenda item the utilization review issue. So that'll be number one. Number two is that we in the Enforcement Committee at the Medical Board want to be in full compliance, of course, of SB 1441. So we'll put that on the agenda as well. And in the meantime, our staff will, I'm sure, take whatever actions necessary to be sure that we're in compliance. We not only want to be in compliance, we want to be a good example for SB 1441. So any other issues? Yes.
So could we also have an explanation as to how experts are assigned to the work on a case and how those specialties, how we are able to match up the specialty within the practice so that we're more clear on the efficiency of the operation?
Sure, we would be glad to add that to the next meeting agenda items. I think.
Want some more? You want some more items?
What's that?
Do you want more items?
Well, just to be more complete, why don't we have a review of the entire process? So not just assigning the expert, but also assigning the consultant.
Exactly.
So that we understand the process a little bit better.
That would be wonderful. Thank you.
Okay, we've been given charts and presentations before, but you know those are hard to digest during those presentations, and I'm sure that they'll make it more clear for us next meeting. So additional items?
So we're going to get to the point of having a discussion. I know it's part of our strategic plan, but when we're going to have a discussion of the current laws being relevant to the practice of medicine, a review of those vis-a-vis enforcement, the rules. I mean, we have some laws that seem to be getting either outdated or outmoded, and eventually we're going to have to go through these things. And I know it's part of the expectation that we're going to do this, but I just want to put it on your radar, please.
Well, I think it's beyond the scope of the Enforcement Committee.
Oh.
So I think you should talk to Dr. Levine about.
I'd be happy to. So one more thing that might not be beyond the scope, and that is that how do we interpret the priorities as set up in legislation on the deployment of resources?
On
the deployment of resources vis-a-vis legislation, how we set our priorities, given we don't have an unlimited budget, we don't have unlimited staff.
But we have unlimited energy.
We sure do. We sure do.
Everything is a high priority in enforcement.
So everything is the same? Okay.
Well, not everything's the same, but I mean, we get everything done. And
That's
I think
good,
that
okay.
the enforcement section of the Medical Board of California is very committed.
Talent.
With that in mind, could I get clarification on Barbara's, Ms. Yaroslavsky's last agenda item? Are you looking for an explanation regarding the expert review or assignment at complaint unit level, or are you talking about investigation?
Investigations.
Okay.
Well, I think you should just make the
We can do the whole
presentation
thing. How
more
about the whole thing?
comprehensive.
This is the whole thing.
Just make it more comprehensive and show us the process.
That'd be good. The process will be good.
From the minute the complaint comes in until we send it out to the last expert.
Just as an example, it's not intuitive, the difference between a medical consultant and an expert reviewer. And so just being able to, as Dr. Lowe said, see the end-to-end process. Complaint comes in, what happens, where the consultant comes in, where the expert reviewer comes in.
Okay.
So we do make that presentation at the expert reviewer
training.
So, okay, so I think that about wraps it up for the Enforcement Committee today. Any other issues? If there are none, motion, the
Move to adjourn.
Meeting's adjourned. Thank you.
And make certain that they're not off the table, not on the table in terms of interfering with our communication system. Committee members will be using laptops to access materials for the meeting. They're not shopping on eBay. And this is an official meeting of the Medical Board of California, and my role as chair of the Executive Committee is to ensure an orderly conduct of the business of the Executive Committee. We have a designated time on the agenda for public comment, and we'll ask for public comment both on items not on the agenda as well as on each agenda item. And I ask that everyone who wants to speak be respectful of the need to conduct the business in the time we have allotted. I will ask that we limit comments to 3 minutes each for comments both on items not on the agenda and on agenda items. If I forget to ask for public comment on an agenda item and you wish to speak, please raise your hand and you'll be recognized. Also, it would be helpful if anyone who's interested in speaking fill out a speaker slip beforehand, and so that I may call you by name at the appropriate time, and I promise to work hard at getting the pronunciation of all the names right. And that the record of the meeting will be full and complete. If that does not mean someone can't decide they want to speak on an item without having filled out a slip, but I would ask that you fill out a slip after you give your comments. And I'm going to call the meeting to order and ask Mr. Einer to please take attendance and call the roll.
Ms. Shipsky? Dr. Diego?
Here.
Dr. Lowe?
Here.
Dr. Salmonson?
Here.
Ms. Yaroslavsky?
Here.
Dr. Levine?
Here. Great, thank you. We have a quorum. And I will ask at this time for public comment on items not on the agenda. I have no slips. Is there anyone in the audience who would like to speak on an item not on the agenda? If not, Then let's move to agenda item 3, approval of minutes from the September 19th meeting. Can I have a motion to accept the minutes?
So moved.
Second.
Is there any comment, suggestion, correction of the information in the meeting minutes?
I have a note on number, no, it's okay, it's fine. I don't know, but I have the answer.
Is there any public comment on the minutes of the previous executive committee meeting? If not, all in favor of accepting the minutes as written, say aye.
Aye.
Any opposed? Any abstentions? Okay. Item number 4, Ms. Kirkmeyer, if you could come up to the front. This is in response to a request for a report to the Executive Committee on how the Consumer Protection Enforcement Initiative positions, CPEI positions, are being allocated, and I think a bit of the history on those positions. Thank you.
Well, I'd like to provide an update on those positions under the Consumer Protection Enforcement Initiative. I'd ask the members that they would please turn to tab 4, page 67 in their packet. And this memo describes the process for the positions in detail, but I'm just going to go over them briefly and a little bit of the history of these positions. As most of you may remember, there were several negative articles regarding the Board of Registered Nursing back in 2009. And as a result of those articles, and it was regarding the length of time for their enforcement process. As a result of those articles, the Department of Consumer Affairs submitted a budget change proposal, or BCP, for additional positions for all allied health boards in an effort to reduce the time it takes for the enforcement process. As a result of that BCP, the board received 22.5 positions in fiscal year 10-11. 2.5 of those positions were actually belonged to the Psychology Board and the Osteopathic Medical Board for their investigations, and those positions were subsequently given to those boards, leaving the Medical Board with 20 positions. The board began to fill those positions, and we hired 2 staff in the Central Complaint Unit in order to assist with the complaint triage and the upfront review. During fiscal year 10-11, the board had to decrease its positions due to a workforce cap, so the board gave up 2.5 of the CPEI positions, resulting in 15.5 positions that still needed to be filled. The board identified how they wanted to implement these positions, but unfortunately that was when the hiring freeze began, and the board then could not fill those positions. The hiring freeze was lifted in November 2011, and the board began discussion to fill these positions, but then in early 2012, the board was notified it had to reduce its positions by 18.1 positions due to the salary savings elimination. The board chose to give up the 15.5 vacant CPEI positions rather than eliminate any existing staff positions. In September 2012, the board was notified that it could refill these positions as long as the board maintains a 5% vacancy rate. So now the board is in the process of filling those 14.5 positions, and we've met and discussed where those positions should be placed. And there's a lengthy list, but I'm just going to go over there briefly. The board is going to be filling the positions by first establishing a Northern California Operation Safe Medicine unit identical to the one in Southern California. The unit will be made up of 4 investigators, 1 clerical staff, and 1 supervising investigator. By establishing this unit, the unlicensed cases currently being performed by the investigator in the Northern District offices will be transferred to this unit. This will reduce the Northern California investigator workloads and allow them to process the cases more expeditiously. The board will also add an investigator to the Tustin and Rancho Cucamonga offices to bring them to 6 investigators in each office, identical to the other district offices. They only currently have 5 investigators, as to where all the other district offices have 6. Again, this will reduce the caseloads and expedite the investigative process. These additions ultimately add 6 investigators to assist in the board's investigation process, which we hope will lead to decreased time frames. 2 positions will be added to the board's expert reviewer program to assist in expert retraining and recruitment. 3 positions will be added to the Central Complaint Unit to assist in the Quality of Care Unit, the Discipline Coordination Unit, and provide clerical support. These positions will help reduce the time in the Complaint Unit as well as in processing the disciplinary documents. And then lastly, 1.5 positions will be used to conduct malpractice investigations. These positions will perform the review and workup on these cases, thus eliminating them from being transmitted to the district offices. Again, the ultimate goal is to reduce the workload in the field in the district offices. All but 4.5 of these positions have been advertised and are pending final approval from the Department of Consumer Affairs in the recruitment process. The other 4.5 positions should be advertised hopefully by the end of February. Again, the overall goal in all of these hires is to reduce the time it takes to investigate a complaint alleging a physician is in violation of the law. Are there any questions on these positions?
Ms. Salmonson, Dr. Salmonson?
Backing up to where it says the board conducted investigations for the Osteopathic Medical Board and the Board of Psychology. So 2.5 positions were authorized for the board to assist, but then it said these boards determined they would rather have those positions back. So I don't quite understand, do they have a complete independent investigation staff? And if so, what was the interface with us?
Well, the difference is back when these positions were originally implemented, the Department of Consumer Affairs, because it was such a broad BCP, they had to do almost a one-size-fits-all. And therefore, they identified all of the positions, except for 2, as non-sworn investigators. So as you know, we have sworn investigators in our field offices, but they wanted a special investigator that would do the work. And they thought they would be able to do the complaints up front rather than going to the field. So some of the boards adopted that. We actually have our own where we send our cases out to the field to do investigations out in our district offices with sworn investigators. The Psychology Board and the Osteopathic Medical Board determined that they wanted to do those investigations in their own units, and so they have, I'm assuming they wanted the positions back, we gave them to them, and I'm assuming that they filled those with non-sworn investigators that are pulled some of the workload then from the medical board and from us investigating their cases.
So then they do completely separate investigations. We don't participate in their cases at all.
We still participate in some of their investigations, but it probably reduced, and I haven't looked at the numbers, but I'm assuming that it reduced the workload for us.
Ms. Kirkmeyer, could you just explain the difference between a sworn investigator and a non-sworn investigator?
I can try. I may be looking to Ms. Threadgill. The special investigator, obviously a sworn investigator is an individual who is a peace officer under the Penal Code section. Their rights are that they can do search warrants, they can do arrests, they can carry a weapon. Those are the biggest items that those individuals can do. As to where the non-sworn investigators, in our opinion, are doing more of the desk investigation where they're obtaining medical records, they may or may not do telephone interviews. They're working more in a headquarters office and doing the investigation, more of a paper trail investigation than actually going out interviewing with witnesses, working with district attorneys' offices and other law enforcement.
Thank you. Was there another question, Ms. Yaroslav?
Yeah, I have a question. So originally back when we had 22.5 approved positions, 2.5 of those positions, or 2 positions you took and put them in as, into complaints?
We put them in the central complaint unit. One was a manager in the central.
So they went into complaints, but we were still at the 22.5 allocated from the overall design. So reducing the 22.5 overall design, where you allocate them doesn't really matter, wouldn't put us down to 18. So I'm not quite sure why the total number of 22.5, regardless of where you allocated those people to within your organization, why is the number that we're looking at 18, which has now gone down to 15?
So we originally had 22.5.
Right.
We lost 2.5 to the other boards, which took us to 20. Then we filled 2 of them, which took us to 18. Under the governor's workforce cap at the time, we had to eliminate 2.5 positions.
Wait.
Okay.
So the 22.5, 2 went to the osteopathic board. And
2.5 went to osteo and psychology, so that takes us to 20.
Right.
Then 2 of them were filled, So they were filled.
Two of them
in our
were
central,
filled?
Were filled, so we had hired a manager and an analyst in our central complaint unit, the two you were talking about. So then that took us to 18 vacant positions.
Why do we lose, why, I don't, you had 20 positions that were authorized for the medical board to be used wherever the medical board felt it was important.
Right.
A reduction of 5% of the 22. I'm not sure why, just because you put them in a different position, why they're not still part of the original plan to give you the same number, the certain number of specific of people.
They are. I'm just saying we have 2 CPEI positions that before all of the other events happened, we filled, and they're currently working for us at the board.
Oh, they are, okay, so they're still part of your original
still
count.
part, yes.
Okay, I thought you were losing them from your,
Yes.
okay. I
So
thought
actually,
that.
the 14.5 that we're filling, we have 16.5
You have 60,
that we
okay,
were able
that's
to
what my
fill.
concern
Yes.
was, is that we were losing more than we needed to lose, okay.
Any other questions? Any comments from members of the public on this? Okay, thank you very much. Let's move on to agenda item 5, which is review and potential revisions for the board administrative manual. Mr. Hepler, could you please join Ms. Kirkmeyer?
Certainly.
Thank you. And present on the item. There will be a number of motions that need to be made as part of this discussion after the committee has discussed them. And you all will let us know when we need to make a motion. Is that correct?
We will.
All right.
Mr. Hepler will. Okay. If the members would please turn to tab 5, pages 69 to 86. I would actually like to walk through the edits that have been made to the manual based upon comments from the members and items that staff have been requested to update. I will not be going over edits that were grammatical in nature, as I'm sure you've all looked at those, and I don't think we need to discuss those. Edits have been identified in red underline. After discussion, Mr. Hepler will assist in the discussion on any other items that you wish to be added or deleted. I would like to point out that the memo on page 69 had the wrong place numbers identified, where it had page number 114 to 115, that actually should be 80 to 81, and page 118 should actually be 84, as we're going through if you want to look back at those. Okay, so I'm going to ask the members to please turn to page 76. Since the board has begun webcasting its meetings, an update was needed to this section based on the fact that we now do tape recording to bring it in alignment with the new technologies available. Basically, before it said tape recording, we want to add webcasting, and we added information about how long those webcasts would stay and when they would be available.
You might want to correct the word kept to K-E-P-T.
Just a spelling mistake.
Spelling error.
Oh, that's a great idea.
Unless there's a new word, and I'm not, maybe that's a technological term that I'm not familiar with.
When it says that the webcast will be kept for 10 years, does that mean posted on the site, or does that mean archived?
It will mean we will post it on the site as much as we're able to due to size limitations. That's my only concern. We really haven't gotten, now that webcasting is so new, we haven't talked about size and where we're going to store all of those, but as much as we're able to, we would store them where they were archived, there where you could actually click in and then see them.
Thank you.
So before you finish that subject, it seems that this isn't the only board that's doing webcasting. It's not the only board that needs to have storage space. And it's not the only board that's going to have to pay attention to that. So I might suggest that there be some kind of collaborative opportunity discussion so that the shared space is sitting in a file cabinet somewhere up there or wherever, and it's still accessible via the web on each board sites.
We can do that. Just so you know, the Department of Consumer Affairs a year ago made the decision for them that they weren't going to keep them out there, and they removed them. That's why we actually went to YouTube, and so for any of the older ones. So we actually went and developed our own site. So we will look into that. We'll put them into a virtual cloud. I know that our IT unit has a better idea of what that means than I do, but we will look at definitely at storage.
So what you're saying is the other consumer boards in the state are not maintaining records of
Everybody
webcasts?
maintains records according to their records retention schedule. So I don't know what the other board's
Interesting.
records retention schedule says, and this will be something we're looking at as well on ours.
Okay, thank you. I'm sorry.
Well, Madam President, members, never missing an opportunity to keep my mouth shut nor speak. I just had a question. It says will be posted on the board's website. Somebody mentioned YouTube. Do we post to both, or how does?
Our website links to YouTube.
Our website links to YouTube.
So we have our own YouTube channel.
You're asking the wrong person that. All I know is I can pull up YouTube and watch us.
Okay. I just was curious whether it was posted to YouTube or posted to us. That's
It's stored on YouTube.
okay.
So the issue is, as far as the consumers around the state of California, is that noted in the bulletin or newsletter anywhere? I mean, if it's as long as it's on our website, we don't need to bother.
So on our website, if you go to board and committee meetings,
it'll be
and
there.
It's there. If you look at, so like for example, right now, like the October board meeting, you would see October, you'd see the hard copy packet, but then right under the under the date of the meeting, it says webcast. You click there and you go watch the webcast.
Okay, that's all. As long as it's available. Okay, thank you.
Okay. I need individual votes. Can I do one?
I think if the way to do this would be to sort of wrap up everything together and then do a motion. Otherwise, we'll probably consume a lot of time doing that.
You'll have too many.
Then if we can turn to page 77, we actually had an edit explaining why a speaker slip is requested on this page. And then also on page 79, there was a section deleted that did not seem appropriate for the manual, so we've removed that as well.
Madam President, members, returning to page 77, to conform number 4 with state law, I would request that item number 4 on page 77, the second line read, our committee of the board shall be requested to complete a speaker request slip, or shall be asked to complete a record. Because as has been pointed out, there's no mandatory requirement that you complete when we do that for essentially maintaining the order and also having a complete record. But as far as state law is concerned, I just think we need to be consistent.
Okay. And then the biggest addition occurred in Chapter 4, page 80. Edits were made to the election of officers section to bring it up to date with current board procedures. In addition, changes were made to panel members section indicating the president can sit on a panel if the board does not have a full component of members. Based upon requests from the members, a section was added on page 81 outlining the role of the board officers, committee chairs, and panel officers. Also added at the end of the document was a section outlining a board member's responsibilities, and that's on page 86. This document was provided during the DCA board member orientation, and it was thought that this document should be placed into the manual. So are there any questions or edits then on page 80, 81, or 86? Yes, Dr. Levin.
On page 81, under President, I'm just discovering some of the responsibilities in vivo. One of the things, a bullet should be added to say something like represent the Medical Board of California at meetings of the Federation of State Medical Boards.
And maybe we should expand that to include other such meetings as that. Okay. Are there any other edits to that section?
I have an exceedingly small and nitpicky edit. As far as the president's duty, the fourth line down, may talk to, I would suggest use the word media instead of press.
Where do you see it in the first place?
It's fourth line, second word in.
Oh, sorry, thank you. Let me ask you a question. By denoting that, I'm not sure why it's included, because the president does speak for the medical board, and when necessary, speaks to the media or to whomever else. they speak to. Why are we limiting, or why are we including who they can or cannot speak to? I mean, we don't, as a rule, it's not a privilege that we give or take. It's part of the, you're speaking to for the medical board, period. You may attend legislative meetings. I mean,
I asked actually that
have it be included?
the specifics be articulated.
Okay, then I
because
apologize.
as
Okay.
someone coming into the role, it was not clear to me, other than chairing the board meetings, exactly what was expected of me. So I
Okay,
asked
then that's fine. I apologize.
that it be articulated.
And actually, according to the policy, that really is the board president's role as the only one, unless somebody else has been delegated to act on behalf of the board, I believe. Mr. Hepler?
Yeah, generally speaking, the power of the medical board is vested in itself, not in individual members.
Right.
So generally speaking, unless somebody's been duly authorized or duly delegated by the board to represent the board on a narrow issue, generally that power is vested by the adoption of this in the president. And
It just seemed that this was a new charge. That's why I was questioning.
It seems it's more enumerated.
I have a comment. Wouldn't just leaving the spokesperson for the medical board cover all of that instead of, well, I can appreciate the enumeration, but there may, someone 4 years from now may say, but it doesn't say that, so therefore, it almost like needs to have something else.
Limiting rather
Yes.
than.
Yeah, such as
You might have
including but not limited to, or something like that. Including but not. Thank you, Sylvia. It's the not limited to that gets you every time.
Then with those, if there's no other edits, I would actually like to ask for a motion to accept the changes that we've identified here prior to moving into the next items, because I think we would need to take those on an individual basis.
Second.
All in favor? Oh, sorry. We need to ask for public comment, excuse me, on this agenda item or on this motion prior to voting. Seeing none, all in favor?
Aye.
Any opposed? Any abstentions? Okay, so moved.
Okay. Then at this time, I'd like to move into agenda item 5A, the roles of the members upon media inquiry, and I'm going to ask Mr. Hepler to speak on this.
Certainly, thank you, Ms. Kirkmeyer. I guess the issue stems from, what is the role of a member upon the media inquiry? Generally speaking, from a staff perspective, I'm trying to draw a clear distinction. If somebody makes an inquiry of staff, that inquiry is directed to the public information officer. Am I not correct? Or his or her designee. So the question is, not trying to equate that to staff, is there some direction that this manual could give to members when contacted by the media? And the reason I say that is, candidly, there may be a concern that no matter how many times you would say, I'm a member of the medical board, we have not taken a position on this issue, or this issue has not come up for public discussion or deliberation, there may be some concern that there may be some mischaracterization or misrepresentation that, in fact, X talked to Y, the medical board, and here's how the medical board feels about this issue, when clearly there may or may not have been any, established policy on the issue. So I think that issue kind of sprang up. I think there also in full disclosure, I think there also needs to be some consideration given to some of the tentacles of the Open Meeting Act, so that if in fact we have any issues with sort of making a comprehensive or run it through all the board members to see how they feel kind of an issue, that we don't run afoul of the Open Meeting Act. So that was kind of the genesis for 5A. I don't know what the answer is. It's merely sort of bringing it an issue. I don't think that we necessarily want to overcompensate or undercompensate. I think it's more of an awareness issue of what should a member's role be upon a minute inquiry. Should it be contact the public information officer, or should it be contact the press? That's kind of the inquiry, I think.
And the current process is that the board members usually contact the public information officer or Ms. Whitney regarding a media contact. But that isn't defined in here. I don't know if you want to define it in there or change it.
And the question was raised because several members of the board are very comfortable with and experienced in communicating directly, responding to media inquiries, and raised the question of why they couldn't, in fact, understanding they could not represent the board, or in fact discuss a policy that had not come before the board in which the board has taken action, why they could not ask the question, could we not just be courteous and take the call, listen to the concern, explain that they cannot speak for the board and that they cannot speak about anything that might come before the board. The concern was not being able to respond to the inquiry. And I think as long, so the question for the board is, what do board members feel, number one, about being comfortable with doing that, and number two, whether there should be any constraint on board members from responding to a media inquiry with the understanding of the kinds of communications that should not happen.
I'm sorry, Madam President, just to preface just to go backwards, of course this is not, there's certain things that are sort of, in my opinion, somewhat off limits. That is like an investigation, the process where we are in the status of investigation. So, that kind of thing generally is not released because it's not considered public information. So I just wanted to throw that out there as well.
And if the board, I think the board feels that members would like to be able to do this, clearly we will need to put together some guidelines that are very specific about what is permissible communication with the media and what is off limits. And we don't want anyone to be in the position of being caught and trying to make it up on the spot. So I'd ask for.
Right.
So I can argue both ways, but I think that when looking on a go-forward basis on an opportunity to be more engaging with our stakeholders, and the media is a stakeholder, and they are partners in the work that we do as far as providing and disseminating information to their public, having a conversation with people in the media shouldn't be something that is either frowned upon or objected to, as long as that within the parameters you're not speaking for the board, you know what kind of areas you can and can't express yourselves, and that you for sure have been admonished that it's not on the record for attribution. But I think that just as we are expected to represent the public and in our interest being public protection, I think that the public also includes the media. So I think I would suggest that I think we have to tread carefully here. There would be training, and then there would be understanding, and also I think the executive director has to be apprised when someone is talking. But we've had it in the past where it's not such a big deal. On the other hand, it's better that you have a clear, concise message going out from either the president and the chair of the board and the executive director. So I think that regardless of what the decision is going to be, I think board members need to be apprised very definitely of what they can and cannot, what areas they can and cannot get into. And I don't think that we should be afraid of the idea of them having that information.
And the other thing I think is that no board member should ever feel that they have to speak to the media if they're not comfortable doing it.
Absolutely not.
This would be in a situation where someone is approached and feels comfortable staying within the bounds of what's acceptable communication.
We all have to remember that the only thing that the press can print is what they're told. So if you don't say anything, they can't print it.
And that, yeah.
Or they can and they will, but we don't want them to. But I'll do fairness.
So,
there.
And Mr. Hepler, is there within the statute or the statutes that govern the operation of the medical board, or within our guidelines, anything that is specific that would either constrain or enable this?
I'm not aware, Madam President, sorry, I'm not aware of any distinct and discrete prohibition. I just would, point out that again the power is sort of vested in the board as a whole. I think everybody here has raised pretty excellent points. You see the tension between being non-responsive or being responsive. You also, of course, have the understanding that no matter how many times you say we don't have a position on that, that runs a danger of mischaracterization. You know, as your lawyer and with a high-ranking policy person sitting next to me, I think perhaps what we may want to do is maybe those guidelines that Ms. Yaroslavsky spoke of, maybe before we define that, perhaps the board members would like to kind of see in front of them sort of the things that are, I hate to use the term on and off limits, but maybe on and off limits, that sort of thing before they proceed with making a decision on this issue.
I would suggest that it should be part and parcel of board training. I think that being a board member, in addition to knowing all the rules and regulations and what you have to do, also your responsibility as a public citizen on this board and what you can and should consider not doing. I mean, somehow we've got to deliver the message what we want delivered. So either be it a training or be it more in black and white. I'm trying to give you the parameters to do what you feel comfortable with, but by the same token, I'm suggesting that we have people that are appointed to this board of a position that they need to know what they can and can't do within certain guidelines. So just
during board member orientation, we do talk to them, and we go by the policy that was set by the board, I don't know how long ago, but that the members actually shouldn't talk to the public unless they've called.
Shouldn't talk to the press.
I mean, yes, please talk to the public, no. Talk to the press unless they've contacted the executive officer and that the board president has either authorized them to speak to them but it's definitely run through the executive director and usually then through the public information officer to not put the board members in that position.
So we won't take action on this today, but would ask that at the next committee meeting we agendize a full description of an explanation of what a process and procedure as well as guidelines on.
Then can I just ask, according to what Ms. Yaroslavsky just said, I'm taking it that the policy that's currently in place should continue, and we will just clarify that and put that in the packet then as to what to do when they get a call from the press. Okay, we can take that direction. Thank you.
Thank you very much.
Okay, and then 5B is meeting with the public and interested parties. And this is very similar to the prior one to some degree in that we only have a section on page 84 that talks about communication with interested parties. And this was something that was added, I believe, actually in the last revision that we had to this in 2009. And this was more of when you do talk to an individual that you just make sure that you do present that here at the board meeting. We added that as an agenda item. But we've had some recent discussions where individuals have wanted to meet with individual members, and we would like some direction from the board as to those meetings. And I think Mr. Heffler wanted to talk a little bit about that as well.
Okay.
Or not?
So I think if you look at, as Ms. Kirkmeyer said, 84, page B, I'm sorry, 84, page 84, communication with interested parties, I think there was some sort of an issue raised whether there would be some sort of prohibition to meeting with an interested party. Now, I would have to say that if this is if the meeting involves some sort of contested case, some disciplinary action, some sort of complaint, I think we could all answer the question. That would be yes. But as to a true policy matter, I'm not aware of any discrete prohibition that you could not meet. I think that is one of the functions of a public member of a board is to interact with the public. So Ms. Dobbs may want to comment too. I can see no attorneys would call it prior restraint. I see no prior restraint recommendation here. I think this sort of our policy on 84 sort of takes it from the reverse direction. Go ahead and meet, but then report back. And so the question is, does the board want to consider? And again, this is not in consideration of those things that would represent an ex parte communication, investigations or disciplinary or licensing matters in play. This is more of, hey, we have an issue that whoever it is, X wants to meet with Y, a board member, is there some sort of statutory prohibition against, doing that sort of thing? I would suggest respectfully, no, there's not a prohibition. So with that, I'll leave it alone and see if my colleague has anything to say in that regard.
I have nothing to add. I just want to say, though, that as with any other citizen in our country, the board members have a freedom of speech. And so the guidelines that we would provide for you, though, is to just ensure that whatever it is you're talking about, it's something that is not contrary to a position that the board has already taken or something that the board has not made a decision on yet. And you're certainly free to talk with members of the public and to listen and engage with them as long as it is made clear that whatever comments you made is a personal one and not coming from the board and is not an official position of the board.
Great. So if I could ask then if we could have also for review at the next executive committee meeting guidelines for communication with interested parties that would lay out both what Ms. Dobbs and Mr. Hepler said. Again, clearer we could be. I think the more comfort people will have. Ms. Yaroslavsky?
I would suggest also something in the reverse. So in addition to the fact that the public, the board members can talk to the public to the extent of it's nothing to do with an ongoing investigation or a case or policy regarding discipline or licensing, that by the same token, the question then would become, well, do you want board members to be able to go out and engender questions and answers? So do you want board members to going and making a point of, and I don't think you do, that's why you don't want me going out to speak and call up a public citizen in Washington and say, I'm going to be in Washington, D.C. the next week. I'd like to have a meeting with you. That's what I'm saying. I think that we have to be cognizant of the fact that we do sit as members of this board, and we have to be respectful of our positions as well as the position of the board, and we don't need to be going to look for. On the other hand, walking along the street or walking in our daily lives, there's the opportunity of meeting with numerous people that might have interest in what we're doing, and having that discussion is fine. So I just think to be careful how it's phrased. We don't want people going out to look for opportunity,
So you're reminding us, I think, of our duty of loyalty and duty of
expectation of your fulfilling your
to the
responsibility
medical
right
board
here.
as board members.
Right.
Before we move on, Madam President, members, since this audience is probably replete with public and interested parties, perhaps we ought to see if there's any comment they have on that sort of action.
Thank you. Even though we're not taking action, is there any?
I think it might be advisable to.
Thank you. Are any members of the public would like to comment on this prior conversation? It will come back next time to the executive committee also. Please.
Tina Manassian, Safe Patient Project, Consumers Union. I'm not sure if this is part of this subject, but I'm going to put it out there. Just recently, I assisted a senior who's blind and disabled to go to the doctors. And while I was there about an hour and a half. While I was there, I didn't see any disclosures on the doctor's wall regarding the NBC regulates and licenses all doctors. So after I dropped her off, I called medical board, and I was transferred to the outreach person. And when I told her what happened, she said, well, file a complaint. I'm like, file a complaint? Why would I do that? That's not using your resources that well. She says, well, then what do you want me to do about it? We can't police every doctor. Wrong comment. And then she said, well, why don't you just call the doctor up or go to the doctor's office and tell them to print out the disclosure on the website? First of all, that's not my job. That's your job. So how do I deal with that? I'm just a consumer out there looking out after
Thank you for
you guys.
Thank you for raising the question. Ms. Whitley?
You file a complaint, so we have the doctor's name, so we know who it is that we can then contact and follow up on. That is the process. And your discussion, you could have been transferred to the
complaint unit, but it really does help to have that in writing so we know who it is. And if that is a complaint via an email to me, I was in this doctor's office, didn't have disclosure, because what may have been is disclosure could have been on the informed consent materials that you may not have seen, because that is by law appropriate. But again, we would have to look at it, and it is considered a complaint.
Small c.
It's a violation of the law. That's why it would be a complaint.
Okay, thank you. Any other comments on this? If not, we can move on.
Okay. I think we'll reverse roles, and I'll lead off with this one. I think, candidly, I think one of the things that was talked about, will be talked about in full board session, is this, the possibility, the potentiality, the capability of the interactive teleconference, telecommunication, webcasting events that, you know, may surround the meeting. And one of the things that I wanted to bring up was, does the board wish to establish, you know, a policy on when it receives written comments on items on the agenda? I need to differentiate this between, this would be items normally appearing on the agenda, and I must contrast that to our traditional regulatory process, where by law we take oral and written comments. As a matter of law, we must consider them whenever we promulgate regulations. This is a little bit different in that, you know, if somebody says, well, you know, the board is going to be considering this legislative package, and SB 1, I don't want the board to take a position on. So I'm just curious, does the board want to consider, you know, that it'll act as a sort of receptacle for those kind of comments? Is there any traction there? I don't know how many we have, but I just wanted to throw that out there as something that perhaps the board would want to consider.
So if I understand what you're asking, we publish the notice of the meeting with the agenda.
Correct.
And currently, the only way someone can comment on an item on the agenda is to come to the meeting.
I'm not exactly certain. That may be. I think we have, in some points, we have in various things read certain comments into the record.
They can write comments.
Okay.
Yeah. But the question is, I don't believe there's a universal policy on that, a universal, all-encompassing policy on that issue. I think we sort of deal with it on a case-by-case basis. I was just curious, as your lawyer, whether you think perhaps, you know, some universality is warranted here, or is it something you want to address on a case-by-case, or would you like to have us, again, sort of, you know, maybe throw out some ideas and concepts and bring that back to you at the next meeting as well? So that was the nature of my inquiry. I know I've assisted in meetings before where we have gotten a fax or letter at the last moment. Somebody was, you know, dying to come to the meeting, probably not a good word, dedicated to coming to the meeting. Some unfortunate or unforeseen event happened. They weren't able to make it, but they sent a fax to the hotel. They sent a fax to the executive director staying here to her attention, and then we would read that into the record. And so I'm just asking you, do you want to consider more of a global procedure? And if that's the case, we could certainly, if you wish, you could direct us to come up with one. That was sort of the nature of my inquiry.
I think you can come up with one, but on the other hand, you know, we're not talking about doing brain surgery here. No offense to any brain surgeons in the audience. It seems to me that if the public is going to take the time to address this board by whatever means, either in person with a notice or without a notice to speak for 3 minutes, or wants to send a fax or a video, it doesn't matter. The thing is that someone has to be able to receive it and someone has to be able to disseminate it. So I would venture to say that yes, if we're going to have to start going to that level, I would say that in the way of openness, there's no reason that if we do get something, it goes to the executive director, copies are made and distributed to the members of the board sitting behind the table, and the 3 minutes that you take to read it, you read it, and then it's over and done with. It's not a real tough.
I don't think it's, like I said, I don't disagree with any of this.
If you're looking to have that thing, I vote for doing it.
So perhaps we could have you come back with options for that?
Sure, certainly.
But I don't want smoke signals, okay? Or, you know, Morse code, something like that.
Well, and I think one of the questions with this is when members address us, both the public and the rest of the board members have the benefit of that input. And so I would think that if we have written comments submitted, we would want to read them into the record. So if you could come back to us at the next committee meeting with options.
Certainly.
And I have I believe this is on this agenda item, Jack French.
Good afternoon. I'm Jack French. I live in Escondido, California. I'm here on behalf of the Consumers Union Safe Patient Project, a nationwide campaign that's organizing patient safety advocates from across the state, California, as the California Safe Patient Network. It is clear intention of the Bagley-Keene Act to enable the public to monitor and participate in the decision-making process of boards like the Medical Board. Unfortunately, Consumers Union California Safe Patient Network activists have found barriers to communication with the Medical Board. We have several recommendations about how the Medical Board might foster more open communication. As an example, an activist who was unable to attend a meeting in person wished to submit written testimony to the Medical Board. There is no information up on the Medical Board's website to explain to a member of the public how to go about doing this. The activist contacted the Medical Board by phone to learn how she could submit testimony since she was unable to attend the meeting in person. Medical Board staff told her they needed to consult with her attorneys to be able to answer her question. After Medical Board staff got back to her and explained their protocol, she submitted her testimony. Staff summarized this testimony verbally to the Medical Board members during a board meeting. The activist did not feel the summary was an accurate reflection of the issues her written testimony addressed, and discovered that none of the board members were given her testimony. The Medical Board staff has informed us that they do not provide the board members with written comments when they have to do with a particular case before the board. We understand that this staff may need to screen comments for this kind of information, but do not think all comments should be treated as they fall into that category. This particular testimony was not about a specific case. This attempt to try to block board member meetings with patient advocates seems to particularly inappropriate coming from a board whose mission is to protect consumers. We urge the Medical Board to make clear and prominent on its website the opportunities and rules for public participation in Medical Board meetings, including how to submit written testimony to board members, provide Medical Board members with easy and timely access to all testimony, other written correspondence directed to the Medical Board, so Medical Board members may have the opportunity to read it themselves, provide on its website a link to all testimony and other written correspondence directed to the Medical Board, except of course those that are confidential in nature, and facilitate communication between individual board members and members of the public who wish to communicate with them. Thank you.
Thank you, Mr. French. Okay, are there any other questions or comments from board members on this item? Or from members of the public? Okay. We're kind of at a decision point here. It's after 3:30.
You can go longer, you just can't start earlier.
I'm sorry?
You can go longer, you just can't start earlier.
Okay. Ms. Kirkmeyer, could you please continue with item 6, the strategic plan update?
Absolutely, it's actually short. So, if you would please turn to tab 6, page 87, you will find an update on the board's strategic plan objectives. The objectives on page 88 to 130 have been updated to indicate the activities that have been completed on objectives with dates that have passed or are due at this time. Their updates are listed with a 1/31/2013 date. Please be aware that the objectives that did not have current or past due dates have not been included in this update. They will be included in the update when they are due. The Chiefs of Licensing, Enforcement, and Legislation will continue to indicate during their committee meetings or during their program updates where the items they are discussing tie to the objectives of the strategic plan so the members know the items are being completed. As you may remember from the report at September meeting, the Executive Committee meeting, many deadlines were extended due to the work being performed on the Sunset Review and the BREEZE project. Once the hearings have been held for the Sunset Review and once the BREEZE system are implemented, we will again be able to focus our resources on the objectives of this plan. Most of the objectives under Goal 3, pages 106 to 118, are being put off until the hiring of a new public information officer and until an education and wellness committee have been held. These items cannot be completed or in some instances cannot begin until this individual has been hired. Also, several of the objectives will be dependent upon the issues that have been presented in the Sunset Review Report and whether legislation is drafted upon the issues brought to the Senate Business and Professions Committee. Staff will be monitoring the Sunset Review process in comparison to the board's strategic plan and will see what items need to move forward after the Sunset Review hearings and legislation is drafted. All other objectives are on target for completion or have been completed as indicated in the status column. Do the members have any specific questions on any of the objectives?
So what I'm hearing is that until you have a PIO in place, there will be no education committee meeting taking place?
I believe that we're looking right now to setting an education committee. No, I didn't say we wouldn't have one. I just said that some of the objectives in here are dependent upon the hiring of that person and then them developing a plan and furthering a plan to institute these objectives. I believe
Because I
right now
thought we
we're
had
looking,
someone, okay, I
we're
just was,
looking for an education committee meeting. We're not.
yeah,
meeting
that's what I
for
thought. I was hearing a double message. She knows I was hearing a double message. Thank you.
Any other questions or comments? I have one, which is, I think in terms of tracking, I mean, one of the board's responsibilities is to track progress on the strategic plan. It would be helpful to lay out a timeline where the planned quarter where implementation was going to happen, and there may be reasons why things are pushed out, but if we could at least see where we are in relationship to what the plan laid out in a timeline that it crosses the 3 years, I think, that are encompassed by it, so that we can look at each meeting to see which objectives are on target and which ones have had to be postponed.
Kind of like a Gantt chart.
Yes. With colors, red,
So
yellow,
down
and
the
green.
side, down one side the tasks and across the top the calendar, and definitely.
Yeah, and red, green meaning on target, yellow slightly delayed, and red
Where they're
has
stopped,
been
yeah.
pushed. Yeah.
Then we could have orange and purple.
Stoplight report. Okay. And then that concludes my report. Unless there's anything else, we will continue to provide updates at the executive committee meetings.
Great, thank you. And just as a reminder to board members that we will continue, based on our decisions last year, we will continue to have strategic plan updates at the executive committee rather than the full board meeting, and will include in the report on the executive committee to the board that we have carried out that responsibility. Are there any questions from members of the public on Ms. Kirkmeyer's presentation of the strategic plan? If not, I will entertain a motion to adjourn.
So done. Moved.
Okay. Meeting is adjourned.
Well, and how long do
At least 5 minutes.
I'm sorry. So, yeah, so we can take a 5-minute break and resume at 3:45. I'd like to call the meeting to order. This is, as you all know, this is a formal meeting of the full board of the Medical Board of California. I'd like to ask everyone to turn off their cell phones or put them on silent mode. And members with Blackberries, please take them off the table so that they don't interfere. We have a designated time on the agenda for public comment on items not on the agenda, and then time for any agenda item. And if I forget to call for public member comment, please raise your hand and I will recognize you. And I have so far one speaker request.
Madam President, before we formally begin, perhaps we could call a roll and establish a quorum.
I will.
Sorry.
Don't worry. This is the paid political announcement. Okay. Mr. Einer, could you come forward and call the roll, please?
Dr. Bishop? Here. Dr. Diego?
Here.
Dr. Gonadev?
Here.
Dr. Lowe?
Here.
Ms. Pines?
Here.
Dr. Salmonson?
Here.
Ms. Shipsky? Mr. Serrano Sewell?
Here.
Ms. Yarvoslowski?
Present.
Dr. Levine?
Here. And Mr. Einer, if you could stand up so everyone can see you. I would request that anyone who'd like to speak fill out a speaker's form in the back so that we are able to keep accurate and complete record of who the speakers are. And again, if you have a last-minute request to speak, just raise your hand and I'll recognize you. And we're starting a bit late. We may take some agenda items out of order, but we will cover the entire agenda before adjourning tomorrow. We have a quorum present. Can I start with public comment on meetings, not on items not on the agenda? Yvonne, Ms. Chung?
Good afternoon, members of the board. I'm Yvonne Chung with the California Medical Association. I'd like to speak briefly about an issue we raised at the Enforcement Committee meeting related to the Medical Board's enforcement of physicians conducting utilization review that doesn't meet the standard of care. This item was approved to be added to the agenda, the Enforcement Committee's agenda for a future meeting. CMA agrees with the NBC's previous position that utilization review does constitute the practice of medicine, primarily because these decisions directly impact the treatment received within the professional sphere of physicians. We would like, in addition to our request to the Enforcement Committee, we'd like to request that the Medical Board place this item on the agenda for a future full board meeting to clarify the board's jurisdiction over violations related to utilization review and how the Medical Board can better allocate resources to provide oversight over utilization review, and to consider legislative or regulatory changes that can improve the board's enforcement authority in this area. Thank you.
Thank you for your comment. We're going to move now to, I'm sorry, are there any other speakers who? Thank you. We're going to move to agenda item number 3, designation of the decision in the matter of the accusation against Edward Spencer, case number 12-210-205-496, as a precedential decision. Ms. Dobbs?
Thank you, Madam President. This case is being presented to you today pursuant to the board's procedure in place to make precedential certain decisions, and the board policy is attached to your package. This package can be found in agenda item 3. The policy is attached as Exhibit 1. And just by way of background, the Spencer case arised out of an accusation filed against Dr. Spencer. It went to administrative hearing and the administrative law judge, the board adopted the administrative law judge's decision. And basically the relevant facts in this case include the board filed a petition to order a compelling a psych eval for the respondent under Business and Professions Code 820. The petition alleged that the respondent's ability to safely practice medicine was impaired, and that due to mental illness. And so the board supporting documents included an 805 report that was received from respondent's employer. Respondent was not provided a copy of the petition and was not offered an opportunity to present arguments in opposition of the petition. And this is in line with the normal procedure, as these are usually situations where public health and safety is at issue. And so as part of the process under 820, notice to the respondent is not required, and an opportunity for them to participate at that level is not required. In the case at the administrative hearing, this matter was raised. The respondent did not make himself available to be interviewed by the investigators of the board, and did not comply with the order for the evaluation, the examination. And so at hearing, they raised the issue that the entire petition process was unconstitutional because it did not offer them an opportunity to, first of all, see the materials that was being presented and an opportunity to object to it. And this case is important and meets the requirements to become a precedential decision because the administrative judge did a very good job of highlighting in the decision why 820 does not require the documents to be provided ahead of time to the respondent, and why not allowing them to participate in that process at that stage is not a violation of their constitutional rights. And so we feel that this decision would be of particular guidance to all involved, to the department, to the board, as well as to respondents in similar cases. We have Ms. Sack-Simon here, who was actually the DAG on that case, and I know that she has some additional information to provide as to the increasing prevalence of people challenging these 820 examinations and the effect that that has on the board and the process.
Good afternoon. In the past couple of years, we have encountered with increasing frequency situations in which the board issues an order compelling an evaluation, either medical or psychiatric, and the orders are ignored. That, of course, requires us to file an accusation on the failure to comply with the order, get it set for a hearing, go to hearing, and get a decision, which means that the investigation is delayed. If we push it very hard, we're lucky to get a final decision within a year, given the congested calendars at the Office of Administrative Hearings and whatnot. It's an unacceptable delay in an investigation in situations where the board has taken a look at the investigation that's available to that point and made a determination that it has been directed by the legislature to make that somebody needs to have an evaluation in order to determine if they're safe to practice. And as I say, it's with increasing frequency that these orders are simply ignored until there is an order after a hearing and a final disciplinary order saying you have to comply with the evaluation. I think that the Spencer decision is a good case to adopt as a precedent decision.
it makes clear several very important points. The first are that the failure to comply with a board order is in and of itself unprofessional conduct and cause for discipline under Section 2234 of the Business and Professions Code. Provisions that we routinely put in our orders requiring licensees not only to go sit in an office and submit to an evaluation, but to cooperate with that evaluation and make available to the evaluator information or records that the evaluator deems necessary in order to conduct a thorough investigation, that's not an unreasonable or unconstitutional requirement to impose upon a licensee who is required to submit to an evaluation. And finally, as Ms. Dobbs alluded to, the board isn't required to go through a protracted give and take with a licensee before it issues an order. We don't have to provide them with our investigation. They aren't entitled to the petition that goes to the board members to determine whether they have reason to order an evaluation. That reinforces the confidential investigative nature of the board's investigation, and it helps avoid any compromise of our investigation during the investigative stage. Our office we would like very much to see the board take the step of making this a precedential decision so that hopefully we can spend a lot less time litigating the investigative stage of our cases and get the information that we need to go forward and decide whether a licensee is safe to practice.
So part of what we're asking today is to designate certain sections of that decision, and basically that would include the factual findings 1, 2, 5, 6, 7, and 8, and the legal conclusions 1 through 5. In your packet, I've provided you with an example of the decision with the relevant sections included, and in place of the sections that are not made precedential, we've had, asterisks. You also have a copy of the decision as it currently stands right now. So I am seeking from you a motion to make this decision precedential.
Second. As indicated, move to accept as indicated.
Yes.
Second. Second. Okay. And any questions from board members? Dr. Gananadeh?
Yeah, I have two questions. I have no issue when board asks or orders a respondent to do certain things and he or she doesn't perform. I think that's automatic. In my mind, it should be sooner than later revoked. But my next one is, before that order, the respondent does know all the investigation, I gather. Is that correct? Because I couldn't get it. What we found is given to him or her when the investigation is finished and the board order is done?
During the investigation stage, the subject of the investigation is not provided with the board's investigative materials. That only happens after an accusation has been filed and we exchange the discovery. Evaluations under Section 820 of the Code are part of investigation, so the licensee does not have access to the investigation at that phase.
But does when an accusation is filed?
Yeah, understand that what gives rise to the 820 is the fact that there is evidence that this person may be unsafe to practice due to either a mental or a physical impairment. And so part of the 820 process is to order this person to undergo an examination. So that's what this part is.
Anyone else have a question? I have a question. By making this a precedential decision, Does that mean the challenges will stop?
I think it will help. It addresses some of the recurrent themes to the challenges that we've seen, and that I currently have 2 writs of mandate that I'm dealing with. It doesn't address all of the questions, but there was a very recent appellate court decision that I think will help stem the flow quite a bit, because it held unequivocally that if somebody doesn't take the exam as ordered and we file an accusation based on the failure to submit to the evaluation, they can't use the hearing on that failure to go in and attack the underlying order. So I think we're getting there, and this is one of the steps.
Can I ask Dr. Lowe?
It only helps the board side. It doesn't help on the other side. So I just don't understand why we don't just refer to this appellate decision.
The appellate decision doesn't address all of the things that Spencer addresses. For example, the appellate decision, it really deals with the scope of a hearing once you have filed an accusation on the failure to submit to the exam. The Spencer decision makes it clear that in the board's view it is unprofessional conduct not to submit to the exam, and that we are not required to provide the licensee with the petition, and that provisions in the order requiring cooperation are reasonable and directed to public safety. So it is a precedent decision of the board that's designed to provide guidance to licensees, to administrative law judges, and probably even to the court, since there is some deference given to boards and how they interpret statutes and regulations in carrying out their business.
Ms. Yaroslavsky.
So I would just like to be clear on a person's refusals to submit to the test will cause what? The accusation to be filed, and what kind of a time lapse are we talking about?
Well, it depends on the how quickly you can get a matter on calendar. The Spencer case, he was ordered to take the exam, and I think we did get the decision 8 or 9 months later.
So given that it's going to still continue, the time lag is still going to be in place, even with this decision once it's made. Is there ever the opportunity to maybe put a stop practice that failure to submit would cause you to have to stop practice for 15 days or something?
If we had a statute that said that, and we have, I know I have tried to get interim suspension orders, right, and our experts, I think understandably, are reluctant to say, no, Dr. X is not able to practice safely because, of course, they haven't evaluated the licensee.
But if they're refusing to come to be evaluated?
Correct. And we don't have anything in a statute that says we can only get a suspension order if we can show a threat to public safety.
Isn't that why the person is being asked to respond with to be tested, or
to determine whether they are
right,
safe? And so we haven't gotten to that
but
point
someone's already assumed that because someone has made the accusation that someone isn't safe, so that's why they have to go for an exam. It's not like everybody has to go for an exam, correct?
Correct.
So somebody that is unsafe is being asked to go for an exam. Someone is not responding to going to get that exam, and the only thing we have is the tool from the Spencer case to file an accusation, which again will take several months to implement. So I'm suggesting, is there an opportunity, or do you have to have already a case that's been decided in order to attach onto that? You don't, or you refuse within 30 days, within a reasonable amount of time to show up, then that means that you have to, so that the person understands what the ramifications are.
So, and you're saying, Ms. Simon, that would require statutory change?
I believe so, yes.
Okay.
Or it would require somebody giving us an expert opinion that this conduct is so outrageous that I have very grave, serious concerns, and we haven't been able to get that.
Ms. Salmonson?
But I
Dr.
thought
Salmonson.
I heard the interpretation that failure under this precedent case, failure to comply in and of itself was grounds for discipline.
It's grounds
Couldn't
for
that
it.
be kind of a statement of this person's got impaired judgment by not basically taking on known discipline. I mean,
Of
it's
course,
a reach, huh?
they aren't, we can allege that they have engaged in unprofessional conduct, which is what we do when we file the accusation, but it isn't established that they've engaged in unprofessional conduct until we have a decision that says that. So, you know, and there are cases where conceivably we could get a suspension order given the right facts. It doesn't usually happen that way because, as I said, our experts just aren't comfortable making that judgment call on somebody they've never evaluated.
See, I don't think anybody has a problem with accepting this as a precedent decision, but it just doesn't have much teeth to it. We need something that's going to actually protect the public during that time lag. So we need to have a statute change.
And that may be true, but for today, this is our best bet, and then perhaps later on the board can consider whether or not they need to seek some sort of legislative change later on down the board. But until then, I think this will get us a lot closer.
You know, there's no timeline. We need a timeline. We need some plan. I think it's fine to vote on this, and I don't think it's a problem, but we need a plan on when we're going to have that additional statute.
So part and parcel of what you're asking us to vote on today, can I also ask that you be required to, let's say, give us a 3-month update as to, in 3 months you would give us an update as to the last year, how many situations this happened, how many egregious opportunities were missed, how many people were, you know, what we need to do is have the facts from you based on what we're going to do to maybe take a look at future opportunities. Because I agree with Dr. Lowe that this is, if you think this helps, where this is, well, I'm glad it helps.
Yeah, and so I think we can look when we talk about sunset review, whether in fact there are additional things that we want to look at in terms of going to the legislature for, we have a legislature that meets every year, and if we feel there's a statutory change that's needed, we have that opportunity to do so.
Right, but I'm suggesting that we need the information to document that.
Yes, and you're asking for
as part of this
a tally of the number of situations where you feel that this presidential decision has assisted in getting where we
and
are.
I'll work with the enforcement staff and the AG's office to get that information.
In the meantime, any public comment on this item? If not, can I have a vote of the board? All in favor?
Aye.
Aye.
Any opposed? Any abstentions? Okay, great. Thank you. Thank you both.
Thank you.
And our next agenda item, don't see Dr. Norcross. Is Dr. Norcross here? Yes, he is. Our next agenda item, item 4, is a presentation that on the aging physician, and we have our very able colleagues from University of San Diego in the PACE program who are going to, we all have the slides, should have received the slides in your packet. I'm going to have them because we're going to have trouble seeing from here.
Yeah, I'm here today just to introduce Dr. Perry. I'm Dr. William Norcross, the director of the UC San Diego PACE program. And at UC San Diego, we're proud to have truly one of the outstanding departments of psychiatry in the United States, and within that, one of the finest programs for neuropsychology. And of course, that's critical to the function of the PACE program, because a certain level of cognitive health is imperative for safe medical practice. And Dr. Perry has worked with us since the PACE program began way back in 1996. He's a neuropsychologist, an outstanding clinician, and I'm certain has done more neuropsychological exams of physicians than anyone in the world, and happy to present him. He'll be speaking on that topic now.
Before you start, Dr. Perry, can I just ask for a clarification? What's the definition of aging?
Excuse me.
I have a
Dr. Perry,
personal
newborn is
interest
aging.
in this.
Dr. Levine, a newborn is aging.
Sorry.
Well, thank you. I'm sure it is a sensitive topic. Thank you. It's a privilege to come and be invited here to address you all. Thank you for that opportunity. So the title is Assessing the Aging Physician and Looking at Neuropsychological and Psychological Factors. And this is an issue that is sensitive and is being addressed by a number of people around the country and the world because we have an aging population of physicians. And this just gives you some examples that in Canada, about 20% of the physician force in the next 15 years will be over 65. In Australia, about 25%. And this is a little old data, but it shows you that about 20% of our physician population is over the age of 65. Now, conventional wisdom tells us that the older physician is a sage, wise physician, and one in which they've been able to hone their clinical skills and experiences. And in fact, we can look back in our, this is an added slide for the board, I threw this in at the last moment. For those of you that are old enough to remember Marcus Welby,
Such a good time.
he's, here he was working as the older physician. Actually, it's the kind of reverse from the typical scenario. James Brolin was the young, brash physician who would stick by the rules, but it was actually Marcus Welby that would bend those rules and come up with the accurate diagnosis and interventions. But this is sort of the cultural mindset we have that our aging physician is, in fact, a wise and perhaps a better practitioner. So to even question whether or not this is an issue, is this ageism? One of the first studies done in 1987 found that, in fact, the older physician had a better diagnostic accuracy. Now, their initial diagnosis may not have been correct, but as they gathered more information, they were better at coming up with a diagnosis than the younger graduate. So then, what are the concerns? In fact, there's a larger literature that has shown the inverse relationship between the number of years that a physician has been in practice and the quality of care that they provide. Now, in this particular analysis, they looked at 62 studies and found only one study that showed improved performance for all outcomes in an older physician population. And the majority of the studies they looked at, it was the reverse. This is another study. They found that when you're looking at complex operations, pancreas removal, heart bypass, that if the surgeon is 60 years old or older, the patient is more likely to die within 30 days. I want to share with you that each of these studies has flaws. These are naturalistic studies where people are collecting information. They are open to alternative interpretation. So I do appreciate that. I hope you do. But there is a large literature to suggest that there is this relationship with increased adverse outcome, increased problem with the aging physician, particularly when what's being studied are procedurists and people who are doing surgery. These are just a number of other studies looking at the relationship between years of licensure and death and complications, and it was shown that increased years since the surgeon's licensure predicted increased rate of patient death. So the question that we have to ask is, why is that the case? What's causing this? Errors are part of life. We do make errors. It's possible that people have engaged in a more... Can you hear me? Hello? Yes, you can hear that? Thank you. So it's possible that people are engaged in a busier practice, are doing more things, and therefore are more prone to errors that are just common to all of us. Some people have attributed this to incompetence, and I'm not sure that that's really true. Is it true that all people who are engaged in errors are incompetent? Errors tend to be multifactorial. Many things are leading to people committing errors. And the question is, are we picking on physicians? Well, it's true that when we work with a population where there's high risk, there is the added responsibility that people are operating in the optimal fashion or engaging in their practice in the optimal way. And when you work in a high-risk environment that is unforgiving of human error, then you must take all the precaution necessary. And we can look to the commercial airline pilots who have a program where they have to participate in medical certificate. They have to receive a medical certificate every 6 months. They have to submit to random breathalyzer and urine tests for substance use, and they have to check out in a simulator. We've gone through their neurological exam and medical exam. It's actually quite extensive, the things that they have to be reviewed on. So this is actually a practice that's been engaged in other professions where unforgiving error is present. So what happens in the aging process? Yes, aging occurs from birth on. It's true. But as we get older, we do have a change in our function. I'm sorry. And that change occurs in all of our organ systems, including our brain. We have a decrease in gray matter, dendritic spines, cortical neurons decrease. We have an increase in inflammatory proteins. And this is also exacerbated by the fact that we have increased stress as we get older. So there's many things happening. We have other things also that may impact us both directly and indirectly in practice. Cardiovascular changes, hypertension, renal changes, pulmonary changes, urogenital changes, decreased visual acuity, decreased hearing, physical strength and stamina. All of these things can contribute to practice and outcome. And certainly when we talk about changes in brain function, we talk about the function of the brain or cognition. So we have decreased reaction time to consider, fine motor skills and dexterity change over time, the ability to learn new concepts and skills, and I'll talk a little bit more about this in a moment, decreased comprehension of complex information, and decreased analytic processing. These are all things that happen as part of normal aging. So let's look at this link here. As I pointed out, it's documented that there are cognitive changes as part of the normal aging process. One of those changes is the slowing of our ability, or the decrease in our ability to take in new information, to learn new things, our reaction time, and so on. Now, when we think about knowledge, we often characterize knowledge in terms of crystallized and fluid knowledge. And crystallized knowledge involves the accumulated knowledge and expertise that happens. It's kind of long-term memory. You acquire it over the course of your lifetime, and it continues to grow and expand. Fluid knowledge involves novel problem solving and spatial manipulation. It involves mental speed. It involves things like conceiving complex operations and managing complex operations. And what we know is that during the lifespan, crystallized knowledge continues to increase. As you have more experience, your experiential knowledge increases. And it's not that affected by age and disease. So you can rely on your experience as you get older. However, fluid abilities actually tend to decrease. You actually reach your peak around 20, and then it slowly decreases. So your ability to rely on those fluid abilities, that complex, novel information processing, actually decreases over time. So in an article in 2002 on the aging physician, they actually looked at these different types of knowledge processing and to try to understand some of the things that occur in the aging physician. And with the notion that the analytic processing tends to decline, so older physicians do less well when they deal with novel, conflicting, and complex patient situations. And I'll tell you by example, in some of the PACE cases that we've seen, it's been my experience that I would meet with a physician who would say, I've engaged in this particular procedure for 30 years without any problem and event. But as we look at the events that brought them to the attention of you all on the medical board, we'd see on that particular day they were faced with something novel and complex. Perhaps they had to simultaneously process two very unusual events at the same time, and that's where the vulnerability lies. So if they are in a situation where they're doing the same thing and seeing the same type of patient they've seen for 30 or 40 years, they're able to process that without any problem. So how do we assess that? If one of the tasks that you ask of neuropsychologists is to understand and assess people's competence, how do we go about doing that? Now, what we do here is we talk about neuropsychological evaluation as an element of a fitness for duty evaluation. And this is an important distinction that I'd like to share with you, at least my thinking about this. Neuropsychological testing is a way that we can understand something about how, I'm going to stand here so I can make reference to this. We can use neuropsychological testing to assess covert disease states. We can look at it for diagnostic purposes. We can use neuropsychological testing to assess an individual and obtain baseline data to see if there's a change over the course of their lifespan in practice. And we can also use neuropsychological testing for fitness for duty, where we can look at the cognitive traits and or deficits or personality traits and deficits that an individual has. And we all do have traits and deficit areas, strengths and weaknesses. So it brings up the notion of, are we identifying impairment? And here, impairment, I took this definition, is that the inability to practice medicine with reasonable skill and safety because of physical or mental illness? Or are we talking about cognitive weakness? And let me share with you my thoughts about this distinction by way of example. And it's often something that is hard for people to immediately appreciate. When asked to assess an older individual to determine whether they are capable of engaging in their practice, we have to know something about what their practice is. And when we have professions where the practice is dependent on a number of skill sets that are most optimal in a younger population, we have to take that into consideration. So, for example, we can compare, hypothetically, an 80-year-old neurosurgeon against other 80-year-olds. But my guess is that's not the question that the medical board is most interested in. They're not asking, does this person who started off with great cognitive reserve and intelligence, do they do better than other 80-year-olds? Your question is, are they competent to practice against their peer group? Can they meet the standard of care? An example, I think, for those of you that live in San Francisco, I think you're all probably consumed with the 49ers. If the question was, if we took Joe Montana and returned him to the 49ers tomorrow, I have no doubt that he throws a ball better than anyone in his age group. But he couldn't play pro football. He couldn't compete at this time. So the idea is that we have to appreciate that what we're asked to do is to look at the cognitive abilities, take into consideration that there are processes that change over the lifespan, and has that impacted an individual and influenced their ability to perform their profession in an optimal way. By the way, if at any point people have questions, please just raise your hand. So some of the things we do in a neuropsychological evaluation is we understand, we look at different cognitive domains. We want to look at the integrity of the brain. But the distinction between, when we do this from a neuropsychological perspective, we're usually looking at it to determine a diagnostic disorder. But when we're doing it from a fitness for duty evaluation, we're taking the neuropsychological piece and we're also looking at taking these cognitive domains and understanding them by virtue of how they influence the ability of the person to practice. So, for example, we can look at premorbid intellectual abilities and their reading skills. Well, that's going to tell us something about whether the person can profit from ongoing, continuing education. We want to look at attention. Now, a person could have an attentional disorder or primary attentional disorder, but we also want to know, can they attend and determine what is critical and salient? Can they sustain attention to information over some time course? These are the areas that we're testing and addressing. Do they have the ability to inhibit incorrect responses? And I hope as I go through these, you're imagining how this turns into practice elements. Can they learn? Do they have problems with memory? Well, clearly, and many people in the community look at that as whether they have dementia or mild cognitive impairment, but more importantly, if this is a weakness area, how does it influence their practice ability? Can they learn and integrate new information and draw from past experience? Can they recognize and recall information quickly? Perceptual motor skills, the ability to perform physical tasks, eye-hand coordination. We saw a physician some time ago. We gave him a test. He did very poorly on a test where you had to use speed and accuracy and manipulate things. That was a major problem area for this particular physician, who was brought to, I believe, your attention because he had a difficult time delivering babies and had an adverse outcome related to that. So we have the neuropsychological function related to the specific area that the person practices in. And then executive functions, which are the higher order functions. How well do they do in terms of planning, decision-making, error correction, and troubleshooting? If you remember the literature that I just shared with you about the aging physician, what ends up happening very often is that the aging physician, or certainly the older physician, is often quick to make decisions, and when new and complex information is introduced, they often have a more difficult time in integrating and changing that or correcting that decision process. One of the instruments that we use as a screen is called the microcog, and it was developed by the Risk Management Foundation of Harvard Medical Institutions. They wanted to test older physicians for cognitive impairment because they wanted to reduce their malpractice liability. So it's a computer-based test, and I won't go through all the details, but it's relatively sensitive to showing cognitive impairment across a wide range of ages. And they looked at age and education norms. And so what I want to point to you here is this is just the overall testing. And what I'd like to show you here is that here we have 1,000 MDs, and over time, their performance declines based on age. Let me go back to this. They do perform higher than just a normative sample group in the community. And here, this is looking at working and retired MDs, and we see that people who are still engaged in practice and working tend to perform higher than people who are retired, but you do see the decline still occurring, and that their ability to perform as their younger colleagues declines as well. And if we look at their individual areas of assessment, we see the same sort of pattern, that there's certainly a group of physicians who are older who perform at about 100% in these areas. And I can go through each one of these cognitive domains and show you that. But there's also a group where their performance drops down, and that drop down tends to be more dramatic in the older, after 70 and older. And this is true of some other areas as well. So one question that I'm asked is, do we have to go through this neuropsychological battery? Can't you just talk to someone and find out if that's the case? And I'm going to show you an example in a moment as to why that's not the case. But there's been a number of studies, and a lot of the very good studies were done where they're looking at laparoscopic procedures and people working in simulators, and neuropsychological performance were the best predictors of people who did well on these laparoscopic procedures and simulator training.
This is a study that we did some years ago looking at PACE data. This was published. I don't have the date up there, do I? It's a while ago. And we saw that individuals that have had problems, that have had adverse outcomes that have been brought to your attention, typically have problems, have scores that are considerably lower than the normal population. Here are some studies. This is a study done in the Michigan group. They actually looked at people's self-report. And what they find is that self-report and self-identity of problems is not at all related to their outcome on neuropsychological tests. That's another reason why just talking or interviewing people is not sufficient. Now, they did a follow-up study, and this is kind of interesting because they found that they looked at senior surgeons and their outcome. They concluded that actually senior surgeons performed virtually like their younger colleagues. And I was intrigued by this. I just, in preparation for coming here, I actually went back and reread the study, and that's actually not the interpretation I would arrive at by looking at their data, and I'll show this to you. First of all, they determined poor performance as being 1.5 standard deviations from their younger colleagues. That's not the typical convention we use. That means those individuals scored just the 7% level, okay? And what we see here is the same sort of pattern. About 25% of the older physicians, the senior surgeons rather, were getting 1 or 2 errors or complete impairment scores compared to their younger colleagues. Now, much of what I've had to say today obviously has application for people who are involved in procedures. If a good part of one's practice is talking to an individual, doing diagnostic work without involvement in procedures, those sorts of characteristics may not be as essential. But when you're doing things where timing has to be in consideration, being able to manipulate numbers and information and new data in your head, that is going to require a certain skill set. And I just wanted to throw a few slides in here because I think it's important that as people get older, or in general, independent of age, it's not just about cognition. There are many psychological problems that are also impacting individuals, and certainly one of them is depression. And I thought this was a good article to quote. And most of the physicians, this is John Mann is a psychiatrist at Columbia, and he says most of the physicians who come to see me for their depression fight it out themselves first. And that's generally what we've found, is that people are often trying to treat themselves, or they're not acknowledging and admitting to the stress and depression that they experience. And of course, you know that has resulted in the fact that for this profession, the suicide rate is actually much higher than in the public. And that's, I think, simply because people live with a tremendous amount of stress that they're trying to address on their own. So I thought I would end by giving you a case example of how this works. And this was the case of a physician not from California, and I've changed some of the factual information, but he's a 60-year-old man who was referred to us for a fitness for duty evaluation. He was sent from his hospital. He had been practicing there since the mid-90s, very well respected. He had 4 counts of apparent wrong side spinal surgery. Now, what had happened was, unfortunately, one of the patients was the wife of someone prominent in the hospital. And so that's how the hospital and the med group that's how he had gotten their attention. He had an outstanding career. He was the chief of surgery at a prestigious teaching hospital before he moved to this current hospital. He was of good health, did not have psychological difficulties, no history of substance use or physical trauma, well liked by his colleagues, had solid home life. He was remarkably articulate, truly exceptionally articulate. He clearly was going to put forth his best effort. When he sat down and met with me at the beginning of the evaluation, he said, I want to know the truth, because if there is something wrong, I by no means want to endanger my patients, and I will surrender my license. So I'm very invested in learning about this. We tested him. He was of above average intellectual abilities, as I suspected. His strengths were in the verbal area, but he performed very poorly on spatial tests, nonverbal tests. He had a lot of errors of omitting things when he was pressed for time, not being able to seek out and identify the salient details that were important. And he took a lot of time. And these are not qualities that you want in your spinal surgeon, obviously. He performed very poorly on tests of manual dexterity. He was very slow in his information processing, and his motor speed was very slow, not only compared to the general public, but to an age-matched peer group. But his verbal abilities, he was so remarkably articulate, it was very hard. And we are very conservative. We understand what's being asked when we do an evaluation. These are people's careers on the one hand, and patient safety on the other. And so we labor over this for considerable time, because it's been under Bill's leadership that we really want to do the right thing. So it was a difficult decision. So in general, though, we did find that the low scores, even among healthy individuals, his average performance on the nonverbal and speeded measures was atypical compared to the general public, as well as those people that had similar years of education. And we concluded that his poor attention to detail, slow processing, poor dexterity can potentially be problematic and affect one's ability to perform surgical procedures, given that surgery requires consistent attentional control and highly skilled, fine manual movements. And that these deficits can emerge and be especially problematic when he's faced with complex situations where he has to sustain attention to critical details and be flexible in his thinking and work under a time pressure. He left, returned back to his home, and while he was visiting us, they did a more focused case review of his work and went back through his records. And they actually found 9 more examples of below standard of care surgical performance. And we were told that when he received all of this information, he surrendered his license and retired, as he said he would. But I imagine that's not the typical outcome. So I use this as an example because if one were to talk with this individual, he explained why those 4 wrong site surgeries occurred. There were specific reasons for each one of them. He was remarkably bright, sensitive, understanding, empathic, hardworking, and yet when we tested him, and he did not meet a diagnostic criteria. This was not a person that had a primary memory disorder, did not have evidence of a dementing process, but had significant impairment in areas that were critical to his area of practice that were uncovered in the testing and resulted in our conclusions. So I thought that was a good example to stop and to see if there are questions.
Can I ask the board members?
I have a question. So within the profession of being a medical doctor, one assumes that the intellectual ability is at a higher level and that certain tasks can be performed better and certain tasks might not perform as well. So how do we determine when we are sending a person, let's say, to PACE, do they go through this type of testing as part of the PACE clinical, when we prescribe? I mean, who gets to go through this? How would we know to recognize to put that as a term and condition? Term and condition. I'm not speaking loud enough. Sorry. I don't know. This is fascinating, but I mean, it's obvious that someone, if they're capable intellectually, that could talk themselves, or it could be the speech and verbal, or it could be the other. You never know which part is going to be up and which one's going to be down. So how do we know when we're reading something to consider that this might be something that needs to be done? Maybe that's the question.
Yeah, well, everyone that comes to PACE gets a complete history and physical exam, and they do complete the microcog. And we go over the microcog results with Dr. Perry every month. Certainly if some are obviously abnormal, we will order a neuropsychological assessment, which is much more detailed. But we have to be realistic. We have to use a screening test, and we also look at what happened to bring them to PACE. We also look at the way they behave when they're at PACE. I mean, we have doctors who get lost in our offices, and some of you have been there. It's a rectangle, you know, it's not hard to get around. So we put all of this together and we discuss it at least once a month with Dr. Perry and select out the ones that we think need a complete neuropsychological assessment. And I will also say that even though this is anecdotal, we have been using the microcog now as the first line screening test for about 10 years, maybe a little bit over that. And I think we have yet to have someone come back and say that there was a cognitive problem subsequently discovered that was not detected by the microcog. So I think the microcog, it's not perfect, but it appears to have pretty good sensitivity to pick up that subset of physicians who are likely to have significant cognitive problems.
Yeah, I would just to follow up on that. So we do screen every individual, and this is the first step that allows us to determine whether or not a recommendation, and this is integrated with other information as well, real life information. There's two types of assessments that are being considered, right? There's the assessment for the individual that has had an adverse outcome or has been brought to your attention for some reason, and then there's the general population where at hospitals perhaps people are now considering assessing the older physician. Quite honestly, one of the things that makes this work rewarding for me as a neuropsychologist is I have a real-life event that I can then go back and understand through fact-finding and neuropsychological testing and help understand and explain why that may have taken place.
Interesting.
So in that scenario, the information that I understand about the adverse outcome is helpful and integrated. You know, if we have an anesthesiologist who cannot have good facility with numbers. It doesn't mean that they have a neuropsychological impairment, but they may not be well suited for the OR. Is that true?
Dr. Selmanson? I guess then I was hoping, and I think maybe you answered this, that you look at why somebody came to PACE and that you tailor your assessment so that maybe you'd be picking, like I like this fine motor stuff, that you might be picking up some degenerative thing in someone who's not even aging. I mean, that's what I'm hearing. You're kind of gearing your testing to how they got there, to PACE, I mean.
We do to some extent, but then there is a routine battery that everyone gets, and the microcog is in there. And what you might be getting at is that there's a personal benefit often to detecting these things earlier. There's a personal health benefit for the physician that we sometimes fail to recognize. And there are many things we pick up. My personal feeling is doctors in general don't take care of their own health that well, especially male physicians, because they've got two things going against them. One is they're physicians, so they think they know it all. And the second is that they're male, which is, you know yeah, sort of the same thing, right? So we pick up hypertension, uncontrolled hypertension, all sorts of things, and that I think may not immediately impair the physician's ability to practice, but that they certainly would want to know about and do something about to prevent stroke or heart attack or something more serious in the future.
Dr. Gnadadis?
Dr. Perry, interesting presentation. Have you seen any studies where it was administered to politicians, especially in the U.S. Senate?
We will strike that question from the record as not being relevant to the agenda.
I'm just curious. You said that 25% of the people still do well. One of your slides showed. And
I'm sorry?
25% of the physicians did well in spite of aging, and there was a middle fraction, and then the bottom 25% precipitously dropped off. How could we identify this routinely? Forget about sending to PACE or the medical board sending someone. How can we really get there without incurring any type of age discrimination, which is a serious issue?
It is a serious issue. And so if and this is just my opinion off the top of my head in addressing this, if the criterion is about performance, then it's independent of age. So if you're a 40-year-old surgeon and you perform 2 standard deviations below the rest of the surgeon population, then there's an issue that has to be addressed. Maybe that can be remediated and improved, but at least we have to identify it. So I don't know that it needs to be an age issue. It needs to be at a level of performance that is acceptable.
So they just follow up on that. If you take the current way of the specialty boards do, that is the recertification and the maintenance of certification requirements, is that negating any of these issues, or is it not?
I don't know that it's negating it. I think that it's certainly a step in the right direction. But again, if I can use the sports analogy, we are talking, or pilots for that matter, we are talking about 2 things that I think need to be just appreciated and recognized, that over time your body changes, as we all well know, and your ability to perform optimally changes. It may be that the physician who is 75 years old and wants to continue, and again, so much of this really applies to people who are involved in procedures, because the demand characteristics are far greater, and the adverse outcomes, the potential for adverse outcomes are greater. In my own department, I mean, you can be a psychiatrist, and it's less likely if you're doing psychotherapy, for example, that you're going to that a mistake or a problem, even if you fall asleep during the session, is not going to result in someone having potentially an adverse event. But where you're doing procedures, that's obviously of great concern. So I think that has to be appreciated. That maybe, I just spoke to a surgeon in preparation today. I was talking with a surgeon colleague who's a minimal invasive surgeon, and he said, when I'm 65, I'm retiring, because I know from training people, and he trains people on using robotics, I will not have the same skill set. Now, I doubt he's going to retire at 65, but exactly right.
So, Dr. Lowe?
So I see here that the FAA changed the retirement age of pilots from 60 to 65. So, I support neuropsych testing, just as a disclaimer. My daughter is a neuropsychologist. But I can tell you that the training of new doctors is not like the training of old doctors, with the implementation of work hour limits and all of the things that go around the training of new physicians. I can assure you that if you test physicians now, the first 5 years out from practice compared to 60 to 65, I'll bet the 60 to 65 wins every time.
I think that's a really good point, but you have to identify what wins means.
Mm-hmm. In any kind of competition relating to patient care, whether it's cognitive or technical, I just don't think that the new physicians are getting adequately trained, and the restrictions are such that we can't do anything about it. Secondly, Dr. DeBakey and Denton Cooley won't be happy with your presentation, and I think that there's a lot that goes into experience that allows a more senior physician to be better than the younger physician. and that the people that do elect to practice into older age and not because of financial need, but those physicians are probably in the top 25% of their class as opposed to the lower 25%. And I think the Denton Cooley and DeBakey are examples of that.
Well, and I want to be clear that I wasn't suggesting that there's no data to support mandatory retirement of physicians, nor is there data to suggest that anyone over a particular age is no longer qualified. It's facing the realities and recognizing that the demands placed on our bodies change the way we function. So the best thing to do is to assess individuals to see, because if you have those folks that do have that drop, then you would want to look at them in more intensively to see if there are problems in their practice.
No, I agree with you completely. I mean, I think that people want to retire at the top of their game, like Michael Jordan. But then after he retired, he decided he was still better than most people and came back to work, and he still did well. But one of the limitations is the expense of neuropsych testing, for one, and two, the fact that many insurance plans won't cover neuropsych testing.
Well, I can actually address that because I'm actually the executive director of the National Academy of Neuropsychology. Almost all insurance plans will cover it if there's a medical indication for it. These cases are more in the forensic area, and they're not covered by the insurance. So you're right.
And I mean, if a doctor wants to go see his neurologist or physician to get neuropsych testing because he wants to see if he's still fit for practice, that won't be covered.
No, that's right.
And we need to make it so that it is covered so that we can protect the public. I mean, neuropsych testing is extremely expensive, isn't it?
No, I don't. I mean,
well, let me answer that. The neuropsych testing is done on the people you send us or the people that are sent to us by hospitals who often have done something really egregious. I don't think any of us are saying that the 750,000 physicians in the United States should undergo something like that. But what I would advocate, and I think is going to happen someday, and we see a couple of hospitals here and there trying to do it, is an inexpensive, confidential battery of assessment tests at a certain age. And that age would be dependent on how much risk you're willing to tolerate. It could be 60, it could be 65, it could be 70. But the microcog, for example, in that setting, people who have not had terrible errors happen might be reasonable as part of a battery. But there are also inexpensive screening tests, not perfect, but inexpensive for depression, for substance abuse, for a whole host of things.
Dr. Solomon? Well, I guess I would be not into blanket screening on a basic age, but because of what you said on that illustrative case, when they went back and looked at his cases, there were actually 9 episodes. So that would make me think that episodes would be the thing that would then bring you to the attention. Events would be the one to trigger it, because that individual in the hypothetical case was 68, and maybe that would have been the age you'd screen at over 65, but it seemed like you wouldn't have needed to set a screening age if there had been a mechanism for those 9 events that they discovered while he's going through his testing. I guess it could have been event-driven rather than, if he had 9 events that were below.
A couple of comments. I just want to go back to the expense for a moment and but the expense in general of a neuropsychological assessment is cheaper than the expense of imaging. So what you might be thinking about, and this is a problem, is that once your physicians have been requested to get independent evaluations in the community, they're often charged a large sum of money, and that makes it difficult for them. So if this were done at a screening level or done earlier or done as part of a program, it tends to be cheaper. That's just the reality.
So let me ask you, should we expect then the doctors that we send to PACE should be pleased that they've been offered this opportunity to be tested so they can figure out what or why their cognitive reasoning skills might be not, I mean, should we be promoting this opportunity for PACE, or we should be considering?
I think
I'm being facetious, but it seems to me that there's a tremendous benefit out there for our physicians that we're sending
this
to you.
isn't the first time we've been
Facetious?
apprised of the fact that we are very fortunate to have the PACE
You're
program.
Absolutely, and I really
in
congratulate you
California.
on this.
And I think everything we've heard today reinforces that. I also, I mean, I do think that from our perspective as a medical board, what we're dealing with is event-driven situations where I think this is helpful just in terms of thinking about the 90-year-old physician against, we get a case of a 90-year-old physician. It's helpful to understand that, that a 90-year-old physician may not be as acute, but each of those points on your graphs also represents a range. I mean, there's a range around that, and that there are some physicians who at 80 may be, particularly in the cognitive specialties like cardiology, who may be, functioning at.
I think that's the 2 points I think that are important. Is that one is there is a range, but I think I'd be remiss if I didn't emphasize the fact that as you get older, you're more vulnerable and more likely to have decline, and it would be. There is sufficient data to show that.
That's the way it is. It's life.
Speaking of that, Bill, is there been any prospective studies that took a cohort of younger physicians, followed them for any period of time to see if there was any predictive accuracy in this microcog? That seems like a natural extension of this if we're thinking, and I think it's probably reasonable at some point to start instituting some testing, but that'd be an interesting extension of this. I haven't gotten too senile yet.
Well, I don't think there is.
Any other questions from board members before we ask for comment from the members of the public? If not, I think I see a hand in the back. Could you come forward?
No, you can stay right there.
You can stay there if you'd like. Oh, please come forward so we can have all have the benefit of hearing you. I get 2 opinions here.
Do I have to introduce myself too?
Please do.
Okay, my name's Carol Gottstein. You're mostly talking about male physicians, but there was a slide that went by rather quickly that I thought the information on it was quite stunning about the suicide rate. It seemed like a suicide rate for female physicians is 3 times that of male physicians.
Yes.
I wonder if you could speak to why you think that's so and if anybody's working on that problem.
Actually, I wonder if Dr. Norcross, if you have.
Yeah, I'm a member of a committee at our medical school that was started about 3 years ago for the purpose of suicide prevention. But the way to get at that is through depression awareness, because we think depression in most people who commit suicide is the precursor state for that. And it's absolutely true. No one knows why it is that the suicide rate is so high for women physicians. You might have ideas about it that are as good as mine, but I think there's special stress to being a woman and a physician. It's only been the last century that women have become physicians in the United States. And personally, this is totally anecdotal, but I think one thing that hasn't changed is that women still have the major responsibility for child rearing and all the other things that go along with maintaining a household, and I don't think that really changes once you get the MD degree. Physicians are better able to commit suicide. We know how to do it in a way that has a higher success rate than the general population. We know that is true. And so what do we do about it? What our committee has done, and we've published this just about a year ago in a journal called Academic Medicine. I'm one of the co-authors. The first author is Dr. Christine Moutier, and you can look this up. We describe the process that we do, but it's a multi-pronged thing that's aimed at really everybody in our school, faculty, residents, students. They're asked every so often to complete a totally confidential online questionnaire that assesses for symptoms of depression. We also give grand rounds to everybody there in their department or their clinical unit about every 2 to 3 years, and we talk about the subject and implore everyone to take the survey. And all of this is confidential, and from the survey, the participating physician can communicate with our counselors, who are also members of this committee. They can communicate in total confidence by email, essentially, if they want to. But of course, at some point, they're asked if they would like to meet with the counselor. And so far, everyone has agreed to do that. We've not, to my knowledge, had any outstanding cases where we thought somebody was in distress and was not willing to seek help. The numbers are small. Up until we started this program, the suicide rate at our school was about 1 per year. We have not had any since then. I'm not going to claim it's cause and effect because the numbers are low, but I think it's efforts like that that are going to make a difference, that we have to destigmatize depression, because being a doctor is like being in the military. You're expected to be tough and not to whine and not to show weakness. And we have to get out in people's face and, tell them that depression is a disease or substance abuse is a disease and that they should seek treatment for it. And we're willing to share, we have shared our methodology. It's in the medical literature. And we're beginning to give talks to other groups to help them understand how to do this. We're certainly willing to accept advice for anyone else about how to do it. But it's absolutely true, the rate is 3 times higher for female physicians compared to women with PhDs. So it's not just doctoral training. There's something about medicine.
When you say school, are you talking about UC San Diego or the PACE program?
No, this committee I'm talking about is the School of Medicine. It has almost nothing to do with PACE. I mean, people ask me to be on committees because they know what I do for a living. So in that sense, I'm often invited to participate in committees like this. I'm on the Physician Wellbeing Committee for similar reasons, but those are separate from PACE.
Could you tell me if you have any statistics as to how many female physicians compared to how many male physicians are going through the PACE program?
Yes, and actually I can even tell you nationwide pretty accurately. And of course, the medical board keeps statistics for this in California. But perhaps the biggest risk factor for physician discipline is male gender. I'll let that one sink in, but that's definitely true in a number of studies done not only in California but in other states, Ohio, nationwide. And the number it's about 14%. That's about half the prevalence in the physician population.
Thank you so much for your questions. Any other questions from members of the public or from the board? If not, I want to thank you. Sorry, we have one more question. Could you identify yourself, please?
My name is Joe Hopkins. I'm a family physician at Stanford, and as some of you may know, we have been looking at this question in our institution and considering what we should be doing about it. And I read a few of the studies that Dr. Perry, and I'd like to get my hands on the other references, please, to look at it in more detail. I think that we're looking at this from the perspective of screening. It's clear that the board's experience is in dealing with events, and I think that the physician members of the board and perhaps others understand that screening is an approach where you look at the risks of a particular population, whether that be the whole population or some subset of the population, and then you apply a screening test, hopefully a reliable one, to that subgroup often, and see if there's any problem there. And then if you find something, you can investigate it further. So in this case, an example would be colonoscopy, which is recommended for people over the age of 50 because that's the people that have
I'm sorry,
it.
I don't want to interrupt, but you've got 3 minutes total.
Okay, I'll finish quickly. And the waiting for the event would be waiting until the person had symptoms, blood in the stool, and those kinds of things, which would be tragic. In this case, we're not just dealing with the rest of the individual, but the rest of patients. And so we're inclined to err on the side of being a little more aggressive than we might be with normal screening. The study has not been done to find out if screening physicians would actually result in better patient care, which we'd like to have. But that's how we're looking at it.
And Stanford, if I remember correctly, is one of 2 institutions in the country now that has actually put a stake in the ground. I think University of Virginia.
I'm beginning to hear of maybe a couple of others. If you know of others, let me know.
Okay, thank you very much. And thank you, Dr. Perry, Dr. Norcross, thank you so much.
You're welcome.
Okay, we're going to go on to the Licensing Committee report. Dr. Salmonson.
Well, in the interest of time, I'm going to be summarizing just 2, I think, main points. One is something new on the horizon, and that is the graduate medical education. What we always think of as ACGME has now an international branch, as does the Royal College of Canada International. Up till this point, we've had our pathway for recognizing international medical schools, but we've always required postgraduate education to be either ACGME or Canadian. There may be a pathway for international postgraduate as well. So no decision on that as yet. It's an evolving area, and we're asking licensing staff to keep us apprised. The other issue, we do need a board vote, and that is regarding a change in statute. Now, this event has occurred, and that is the merging of the Osteopathic Association Postgraduate Training, AOA, and the ACGME that I previously alluded to, but the U.S. version. They have merged, and our statutes really don't accommodate that because now MDs might be getting training in an AOA, previously AOA-affiliated hospital. So the wording of the statute change that we would need to accommodate this is to add hospitals that are accredited by the American Osteopathic Association to Section 2089.5 of the Business and Procedures Code. So do we have any questions? Or first, I guess we need a motion to...
So moved.
Okay.
I'm
We have a
sorry.
second?
Second. I'm sorry, I thought we had to also change the Joint Commission language in there?
Yeah, you are correct, Dr. Diego. One of the sort of editing changes, the Joint Commission on Healthcare Accreditation Organizations, JCO, is fully enumerated in the statute. They're no longer called that. They're just called the Joint Commission. So we need to make a conforming edit change because JC is now JC.
Thank you. So, any questions regarding this change?
Dr. Bernadette.
Yeah, actually there are 3 entities which accredit hospitals. The one is, you mentioned, the Joint Commission. Second one is HFAB, which is part of AOA. There is a third entity, which is, I think it's a Swedish company, but all 3 are deemed by the CMS. It's CMS which deems entity to accredit a hospital. So, the better way to do it is any entity deemed by Center for Medicare and Medicaid Services to accredited hospitals should be fine, rather than just naming each one. There might be a fourth one soon. So.
This is about accreditation of GME programs.
Right.
Mr. Hepler, can you help us with this?
Yes, I'm sorry. Our research and our suggestion came from recent developments between the AOA and ACGME, and sorry about that. And so our suggestion is having those programs merge. We are very cognizant of the very possible potentiality that we may have an applicant who went to ACGME training at an AOA accredited hospital, but would be ineligible for licensure even though he went through HCG and ACGME approved postgraduate training. And so we felt that would be a little difficult to explain. In the licensing committee, what we talked about, the way to correct that problem was to offer the OR system, which in a hospital, the location would either be in the JC accredited, old JC Joint Commission accreditation, or the AOA HFAP accreditation. And so we were not apprised that CMS has any, the federal CMS has any overarching authority. We were proceeded on that narrow pathway.
Yeah, just to answer that, actually, if we haven't done that, it shouldn't have anything to do with the potential relationship between AOA and ACGME. That's a totally different issue. But a hospital can be accredited by HFAB or Joint Commission, right. But hospital can have ACGME program, and I don't see a reason why that person is not eligible to get licensed in California. If we haven't changed that, we got a real problem.
Because of the way the statute's written,
Because
which is what this
statute's
is
very specific.
intended to fix.
The only accreditation the hospital can hold at this time for an applicant to be eligible is the Joint Commission accreditation.
So apparently it's not the hospital accreditation that's at issue, it is the education program. And apparently the statutes had only listed Joint Commission hospitals, and we're trying to expand that because that would reflect where the postgraduate education can take place.
Correct. The Business and Professional Code 2089.5 is very specific about where the ACGME training has to occur, and it's in a Joint Commission accredited hospital. Only for medical licensure by the medical board.
So in the future, do you assume that there's going to be a change to that B&P section code to include what Dr. Ganadev is suggesting is going to be happening? So that we should be doing the overarching versus the narrow for current? I mean, I'm just trying to clarify. I'm trying to hear what Dr. Ganadev is saying, and I'm not understanding. I understood exactly what Dr. Salmon was saying, but now I understand what you're saying. I would just like clarification.
May I make a suggestion to the maker of the motion that you also ask the staff to research any other items that may need to go into that revision of that particular statute to ensure that we have addressed the complete issue?
Perfect.
The second of the motion agrees. I don't know who the first was.
I'd asked for the motion. I don't know who made the motion. You asked for it and made it. Oh,
I think Dr. Levine and I did, yeah.
And Sylvia seconded.
Sylvia, sorry.
Dr. Diego.
All right. And then we're taking that as a friendly amendment to request that staff look into the appropriate language to cover.
There's some other accreditation.
Now, does this have to be set for hearings? Is that kind of this kind of thing?
This should be going into sunset
Okay,
for us.
perfect. Okay.
That's what I'm really asking for, so to go in sunset, and then we can look into what Dr. Ganadev has suggested, that there's another one that we maybe have left out because we're not aware of. I was aware of two.
Okay.
So that's where we're at. But our statute definitely needs to be updated to meet the needs.
Well, we certainly don't want to leave anybody out.
So let me ask the question. If this is only going to sunset, what do we need a motion for?
Well, you sort of need to include it in the
To
sunset
include it
process.
in the sunset process. Since we voted on the sunset review, to include the change in the statute in the supplemental.
It's already been, has already been done, so this is like an amendment to the sunset, right? Yeah, so, but you don't have the information, so we can't have a motion.
Well, I think the point is so that there's no gap, we'd better go with this then. And if there's yet a third entity that we need to include in the future,
I think you can
How
forward
about this?
it
How
to-
about the motion should say that this is, and if there are any others that staff comes up with, you'll be included as well. So we do an overarching, we do the narrow, and we do the whole thing together, and we move it forward.
I think that's what.
Is that what we're doing? That's done, okay, thank you.
okay?
I just have a comment on that. Actually, about 10 years ago, State EMS Commission changed that from the Joint Commission to any deemed entity to have a trauma center. So I'm just giving you an example how you can go. Once CMS decided there are more than 2 entities, there are about 3 entities who can accredit hospitals approved by the federal government. So we should all be going that direction rather than stick with Joint Commission, which was there so long ago, was the sole entity before.
So the language has to reflect the openness of the opportunity to change based on the staff decision. That's all I'm suggesting.
The language of the motion.
Right,
of our
the motion, right. The motion has to be broad enough to include any additions or corrections.
Mr. Hempler, Mr. Warden, are you clear?
As we understand the motion, I guess I'll speak for myself, is the board would like to proceed with this, but would also like staff to determine if there's a sort of a better way to write it so we don't have to continually come back here to see if whether there's some overarching federal accreditation process that once the hospital was accredited by CMS or deemed appropriate by CMS, that would fall in the way that an applicant could proceed to licensure.
Correct.
Great. Okay. All in favor?
I'm fine with that, but another one Dr. Salmonson brought out is that in future, because of this relationship between AOA and ACGME, the MDs might be doing residency not at the AOA accredited hospital. Hospital could be accredited by the Joint Commission too, but they will be doing AOA accredited residency.
No, they're merged. That's the whole point. There won't be separate. There won't be separate residencies. Those two
And if I
postgraduate
recall correctly,
organizations have merged.
AOA and
They'll be
ACGME.
called ACGME, right? That's the route
Well,
we decided to go.
I mean, I can answer that. I have 170 residents as medical director. I deal with this. I have both programs. And the merger it's not a merger. Basically what AOA is doing is it's making the ACGME to be the sole entity to accredit programs, but they are still AOA programs. And they still haven't allowed MDs to go into AOA programs yet. But that is the next step. So if that step happens, they should be eligible to get licensure, MDs going through those programs, because it's not a true merger. They're separate entities. But ACGME will be the sole authority to visit and revisit for the accreditation.
Okay. I mean, that's still consistent with what we've moved.
For now.
I think it's also correct when Dr. Donato was correct, when we look at our licensing member, we said ACGME and AOA have reached an agreement that ACGME will accredit all postgraduate training that was previously accredited by AOA. I think we sort of mischaracterized it. I don't think the two agencies have merged. I think perhaps the accreditation or the approval function has merged rather than the two agencies themselves.
Okay.
Okay.
Well,
So we have a motion and a second. All in favor? Oh, sorry, public comment?
I have a comment. I think that this only is pointing us into the direction of merging the osteopathic board with the medical board.
it's exactly the question that was raised in licensing committee. Exactly.
I mean, it only makes common sense to do it. Don't most other states already have that merger? At least many do.
Several do.
And
So does that mean you're against the motion or for the motion?
Well, I'm for the motion, it's just that
It's
with
one
the
of those kind of-
with the integration.
The next logical step is why is it separate?
To start with,
Exactly.
right, why?
Well, Reg, isn't this history repeating itself? Didn't California grandfather all the DOs at one point in the past?
Yes.
Yeah.
Did, and then they became separate
Yeah, I
again.
know,
Yeah.
I know.
They didn't like us.
History repeats itself.
Yeah, see, the issue is
We
that
don't study it enough.
ODs, DOs, may be practicing in our institution, but when there's an issue with licensing or enforcement, then they're dealt with by a different board using different kinds of standards, and it makes it very difficult and confusing. And we should have one standard for public protection, not two different ones.
Agree fully. Economy of scale, savings, cost savings, consistency, absolutely.
Consistency.
So I think we need to put this forward, at least to the DCA,
Absolutely.
for planning.
Future
of it.
agenda item.
Yes. Well, I mean, not for us, but for them. I mean, it's not up to us anyway. It's to the department, right?
I'm not sure how.
Well,
Once you know the history, what happened, I think it's best left it to the political side to resolve. This was a huge issue, even in my tenure at CMA, how the entire community, older DO community, was so upset with what happened in 1970s or 60s, where that was eliminated and they were absorbed and grandfathered. So it's a different issue. So I think
yeah, and we probably need to get back to our actual agenda item, but put this on the agenda on somebody's agenda for future discussion. Okay, can we vote on the motion?
I think we did.
Oh, okay, great. No? I don't think we did. I asked for public comment.
No, we voted. We all said aye.
Let's vote again so that we have a...
Do we have any public comment? Okay. So, all in favor?
Aye.
Aye. Opposed? Okay.
Tonight over popcorn.
I'm actually, I think we've got time for one more report.
Sure.
Enforcement.
Sure, I'll be glad to give the enforcement report. We met earlier today. We had an update from Ms. Sweet on the upcoming expert training program to be held next Saturday at UC Irvine. Remember, we had a prior expert training for the first time in May, which was an incredible success. And this next one is already sold out, and there are people on the waiting list. And there's a following one planned for San Diego sometime in the summer or fall. So it's going to use a similar format to the prior one, but it will have some more feedback, and I am sure that it's only going to get better. Next, we heard from Ms. Katie regarding significant progress in the Central Complaint Unit in terms of lowering case processing time. At the July meeting, she reported that the average number of days to process complaints was in the mid-80s. And since that time, we've been successful in reducing that number by 20 days, which I think is incredibly huge and really is supportive of our effort to reduce the timelines. New consultants have been recruited, and I think that that's the area where we've been able to shorten the most amount of time. In addition, the board is now contracted with a transcription service so that consultants can dictate their report rather than to handwrite or type their own, and that should certainly help things move along much more quickly. Lastly, the managers in the complaint unit continue to monitor the status of the ongoing cases to be sure that if there are any obstacles that are identified, that they're addressed quickly. The last area that was addressed dealt with Senate Bill 1441, which calls for uniform standards for the DCA licensees who are identified as substance abusers. And there were 16 areas to be addressed, and some of those were felt by our staff to be not applicable because we don't have a diversion unit. But I think it's been pointed out to us that, in fact, we are not in complete compliance, and so we put this on as a next agenda item, and I'm sure that our staff will be sure that we are completely compliant. So that was a short but very, I think, informative and productive meeting, and we continue to forge on trying to improve and optimize our enforcement.
Thank you very much, Dr. Lowe. Any questions from board members? And if not, I have one public comment. Tina Manassian.
Good afternoon, board members. Tina Manassian. I'm here on behalf of the Consumers Union Safe Patient Project, a nationwide campaign that is organizing patient safety advocates from across the state of California as the California Safe Patient Network. Substance abusing physicians pose significant risks to patients who typically are unaware of the problem. When these issues come before the medical board, they should be addressed through a comprehensive, predictable process that is publicly transparent and has integrity. We were pleased this afternoon that the chair of the Enforcement Committee expressed the committee's interest in the Medical Board of California's coming into compliance with the requirements of SB 1441. We urge you to come into full compliance with SB 1441 as soon as possible. Thank you for your consideration.
Thank you very much. And I think we're actually going to move the remainder of the agenda items that were scheduled for today to tomorrow morning. We have a deadline we have to meet in closed session. We have to allow our attorney to leave by 6. Is that correct? So we are going to close the public part of the meeting now, and the board members will remain. We have a move to agenda item 11. Pardon me? It's 6. Okay. Can I have a motion for adjournment?
So moved.
Recess. Sorry, recess.
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 So moved.
Recess.
Second?
Can I be a recess monitor?
Okay. All in favor?
Aye.
You can get a 2-minute bathroom break while they're leaving. Barb?